ನಮ್ಗೆ ನಮ್ ಕೆಲಸ ಸರಿ ಇದು ಎಕ್ಸ್ಟ್ರಾ ಏನ್ ರೆಡ್ ಪೆನ್ ಬೇಕಾ? ರೆಡ್ ಪೆನ್ ಬೇಕಾ? ಯೂಸ್ ಮಾಡಿ ಸರ್. ಅದ್ಯಾವ್ದೋ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ ವಾಪಸ್. ಇದೆ ನಾನು ಸ್ಪೇರ್ ಇಟ್ಟಿರ್ತೀನಿ. ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಕೊಟ್ಟು ಹೋಗ್ತಾ ಇರ್ತಾರೆ. ಅದಕ್ಕೆ ಒಂದೊಂದು ನೋಡೋವರೆಗೂ ಕಳ್ಸಲ್ಲ ಅವರು. ಶನಿವಾರ ಕೆಲ್ಸಗಳು ಹಾಕೊಂಡಿದೆ ಮೀಟ್. ಹೌದು ಹಿಂಗ್ ಮಾಡಿದ್ರಿ ಮನೆ ಬರಸಲು ಇದೇ ಫಸ್ಟ್ ಕೇಳ್ತಾರೆ. ಯಾರು ಒಬ್ರು ಕಂಟೆಸ್ಟಿಂಗ್ ಇದ್ರೆ ಒಳ್ಳೆ. ಸೆಟಲ್ಮೆಂಟ್ ಮೆಮೊ ಬಂದಾಗ ಬಾಡಿ ಆಫ್ ದ ಮೆಮೊ ನೋಡ್ಬೇಕಂತ ಬಾಡಿಯಲ್ಲಿ ಬರ್ದಿದ್ರು ಅವ್ರು ಸೆಟಲ್ಡ್ ಅಂತ. ಸೆಟಲ್ಡ್ ವಿತ್ಡ್ರಾ ಅಂತ ಬರುತ್ತೆ. ವಿತ್ಡ್ರಾ ಬರಲಿಲ್ಲ, ಸೆಟಲ್ಡ್ ಅಂತ ಬರುತ್ತೆ. ನೀವ್ಯಾಕೆ ಮತ್ತೆ ವಿತ್ಡ್ರಾ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ದು ಅವ್ರು ಹೇಳಿದ್ದು ನಾವು ಹೇಳಿದ್ದು ಬಾಡಿ ಏನ್ ಬರ್ತಿತ್ತು ಹೇಳ್ಬಿಡಿ, ಅವ್ರಿಗೂ ಹೇಳ್ಬಿಡಿ ಅಂದ್ರೆ ನನ್ನೆ ನಾನು ಹೇಳಕ್ಕಾಗಲಿಲ್ಲ. ಸೆಟಲ್ಮೆಂಟ್ ಬಂದಾಗ ಒಂಚೂರು ಓದ್ಕೊಳ್ಳಿ. ಪಾರ್ಟಿ ಇಲ್ಲ, ನೀವು ಹಂಗೆ ಬರೀಲಿಲ್ಲ, ವಿತ್ಡ್ರಾ ಬರಲಿಲ್ಲ. ಹಾ, ಅವ್ರು ಹೇಳಿದ್ದು ಅಲ್ವಂತೆ. ಅವ್ರು ಹೇಳಿದ್ದು ನಾನು ಹೇಳಿರ್ತೀನಿ, ಬಟ್ ನೀವು ಬರೆಯೋದು ನೋಡ್ಕೊಂಡು ಬರೀಬೇಕು. ಸರಿ ಸರ್. ನಮಗೆ ಕೆಲಸ ಇರಲ್ವಾ, ಪೇರೆಂಟ್ಸ್ ಟೀಚರ್ ಮೀಟಿಂಗ್ ಇದೆ, ಅದು ಅವತ್ತಿಗೆ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಅವತ್ತಾದ್ರೆ ನಾವು ಬರ್ಬೋದು. ಇವಾಗ ಅವತ್ತಿಗೂ ಹೋಗಿಲ್ಲ ಅಂದ್ರೆ ಟೀಚರ್ ಮಕ್ಕಳು ಭವಿಷ್ಯಕ್ಕಿಂತ ಕೆಲಸ ಇಲ್ಲಿ ನಮ್ಮ ಪರಿಸ್ಥಿತಿ ಅವ್ರಿಗೆ ಸ್ಕೂಲಿನ ಫಂಕ್ಷನ್ ಒಂದು ಇವತ್ತರೆಗೂ ಅಟೆಂಡ್ ಆಗಿಲ್ಲ. ಒಂದು ಅಟೆಂಡ್ ಆಗ್ತದೆ. ನಾನು ಹೋಗಲ್ಲ ಅಂತ ಅವರು ಹೋಗಲ್ಲ. ರಜಿತ್ ಅಂತಾನೆ
ಸರ್ ಎಲ್ಲ ನಿಮ್ದೇನೆ ಅವ ಎಲ್ಲೆಲ್ಲೋ ಒಳ್ಳೊಳ್ಳೆ ಲೊಕೇಶನ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ. ಮಗಳು ಮನೆಯವರು ಆರಾಮಿದಾರಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ 3 ಜನ ಲೈನ್ ಚೇಂಜ್ ಮಾಡಿ
ಫ್ರೆಶ್ ಇದ್ರೆ ಮಾತ್ರ
ಸರ್ ಹೇಳಿದ್ರು 3-4 ಸಲ. ಓಲ್ಡ್ ಟೈಮ್ಸ್ ಹೇಳೋದು ಕಂಟಿನ್ಯೂಸ್ ಹೇಳೋದು. ಇವತ್ತು ಅದಕ್ಕೆ ಕಾಯ್ಕೊಂಡಿದ್ದೀನಿ ಇವತ್ತು ನೋಡಿ ಮೆನ್ಷನ್ ಮಾಡಿ
ವಿತ್ಡ್ರಾ ಮಾಡಿರೋದು ಕ್ಲೋಸ್ ಮಾಡಿದ್ದೀರಾ ಅದಕ್ಕೆ
ಅದರ್ ಸರಿಗೂ ಹೇಳಿ ಅನ್ನಲ್ಲ
ನಾಳೆ ಮೂವ್ ಮಾಡಿ ಗುರುವಾರ ನೀವೇನು ಬರೋದು ಬೇಡ ಬಿಡಿ ವಿತ್ಡ್ರಾ ಮಾಡಿ ಒಂದು ದಿವಸ ಅಡ್ವಾನ್ಸ್ ಆಗಿ ಕೊಡೋಣ. ಹಂಗಾರೆ ಹೇಳ್ಬಿಟ್ಟು
ಜನನೇ ಬಂದಿಲ್ಲ ಇನ್ನು.
ಮಾಡುವಾಗ ಹೇಗೆ ಮಾಡ್ತಾರೆ ಗೊತ್ತಿಲ್ಲ, ಟಿವಿ ಮೇಲೆ ಹೋಗ್ತಾರೆ. ಬ್ಯಾರಿಕೇಡ್ ಹಾಕಿದ್ದಾರೆ.
ಸಬ್ಮಿಷನ್ ಎಲ್ಲ ಇದೆ ಅಂದ್ರಲ್ಲ, ಸಬ್ಮಿಷನ್ ಇದ್ರೆ ನಾ ಮೂವ್ ಮಾಡಿ ಹೇಳ್ಬಿಟ್ಟು, ಯಾಕಂದ್ರೆ ಬರೀ ವಿತ್ಡ್ರಾ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ.
With your lordship's kind permission notes.
Matter RFA ಕೊಟ್ಬಿಡಿ. WP fresh RFA.
Yes. The date was given notes today. Both in the computer entry and the cause list entry also I verified. It shows 10-9, but in the order sheet is wrongly showing as 10-10. Matter is not listed today, my lords.
What is that?
Not the GPF scheme, my lords. My senior had argued the matter. Lordship said to refresh the memory. Lordship wanted both the side to argue simultaneously. First 9 when it was listed, Lordship said the matter will be taken today.
Yes.
It's not listed, my lords. My request for tomorrow, my lords. There are 45 employees there. Persistently they are.
Tuesday,
Please,
16. Yes.
Pertaining to judicial officers, Belgaum bench, Belgaum judicial officers. Matter pertaining to Belgaum judicial officers. It has been filed in district Dharawa High Court ownership. It has been transferred to this honorable court.
Fresh matter.
Fresh matter. Next
Tomorrow.
week.
Tomorrow.
Next week.
Fresh matter tomorrow.
Next week, Monday, Tuesday.
Next week, 17th. Yes. Lordship. What is that matter? What is that you are seeking relief? In which department?
Service, my lord.
No, where you are working? Where is?
Resource for private limited. It's a resource for.
Mic use ಮಾಡಿ. ಸ್ವಲ್ಪ ಜಾಗ ಕೊಡಿ.
Resource for private limited, my lord.
Private limited. How can you file here?
My lord, it is acting as a public function, so.
No, that is a private body. You have to go to that civil court or somewhere other remedies, not for high court. It is not an estate under that article 12, madam. Yes.
My lord, I would request you to consider and look into my file, my lord, because even though it is acting as, it is a private limited company, it is doing a public function, my lord.
No,
Under 227 and 226, I filed the petition. I may request you to consider the.
Monday, yes.
My lord, tomorrow,
Memo.
my lord, please.
Monday, let us see. We'll see that file. What
Memo for being spoken, your lordship, in this matter, your lordship, in the already petitioner are retired. That is not that came in this matter, your lordship. Retired ಆಗಿದ್ದಾರೆ ಇದರಲ್ಲಿ. ಅದು ಬರಬೇಕಾಗಿತ್ತು. ವರ್ಡ್ ಬರಬೇಕಾಗಿತ್ತು, ಬಂದಿಲ್ಲ ಅದು.
ಅದ್ಯಾವುದು ನೋಡಿ
28ನೇ ತಾರೀಕಿಗೆ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು.
We'll see tomorrow. Yes,
Please.
chamber note.
Disbursement of the salary.
Hmm.
This court has granted an interim order of stay in 60 to 65 years of the university. Salary ne ಕೊಡ್ತಿಲ್ಲ. ಇದೊಂದು IA report
Salary, let us see, 25th, yes.
ಅದು
Yes, 26th, yes. Yes. 23rd, yes.
My lord, the respondent has not paid, now has not paid the PF amount, my lord, to the petitioner, my lord.
PF amount, 24th, yes.
Much.
Your Honor, income has been deducted and paying the education and household expenditure is being problematic.
26th, yes.
Your Honor, 12th, Your Honor.
My lord, I have filed a memo for withdrawal, my lord. Kindly take it on Friday, my lord.
Yes, withdrawal Friday.
Disciplinary proceedings have been initiated me against after my retirement.
Yes, 26th.
Pending matter, my lordship, any date may be, pending matter, any date.
Yes, 26th.
My lord, there is an, petitioner is, this is not as per the bank rules.
Yes, 26th, yes.
You don't, my lord, the settlement benefits not certain, 21 matter.
Yes, 25th, yes.
My lord, seek,
My lord, consider
26th, yes.
we are seeking for
There is an absence of arrears of 7 years, my lord. In the service.
25th, yes.
my lord,
My
consider
lord, seek.
preliminary hearing. Preliminary hearing.
Fresh matter or old?
My lord, seeking for salary,
Old, sir.
Old. 26th, yes.
seeking salary, disbursement of salary, my lord, not yet received, my lord, I noticed.
25th, yes.
My lord, consideration of IA number 1. Consideration of IA number 1.
IA number 1, 25th, yes.
25th.
Two matters for vacating.
What is that matter?
Service matters of.
Yes, 26th, yes.
Not two matters for vacating stay, interim order is operating against me. I had the liberty to file the application for vacating stay. I filed it, two matters, my lord, where I am paying salary without expecting work.
Yes, vacating application has been out 18th, yes.
My lord, it's a matter of service.
18th better.
19th.
My lord, it's a matter,
Nadagilla, yes.
my lord, it's a matter of transfer. This honorable court has granted an interim order staying the transfer. There are other employees of this company that are using this interim order and resisting transfer. My lord, I appear for the,
Now that if they are using and doing it, you have to decide.
my lord, there's an administrative exigence.
Not here to decide all this.
Indeed, my lord,
Not
there are,
mediation.
my lord, there are administrative
This
exigencies.
is in respect of the petitioner. If somebody is using, you have to deal with.
Indeed, my lord, there's administrative exigency with respect to security of the organization. My lord, I appear for the note press, note
Interim order
printing.
is granted only one person or all.
Indeed, my lord, there's an abuse being taken place, my lord.
That you have to be deal with that. If you are not able to, you resign and go.
My lord,
Yes.
it's-
Transfer matter has become infectious, my lord.
Yes.
Term complete act.
Day after tomorrow. Okay. Yes.
My lords, serial number 44, may kindly grant an adjournment to day after tomorrow.
Yes, what is this? 26th, yes, 26th, yes.
My lord, there's a matter of pressing administrative exigencies, my lords, because the
26th, yes.
grateful, my lord.
26th. Yes, 25th, yes. 25th.
Lord, serial number 44, may kindly have it day after tomorrow, my lord. Senior counsel has been engaged. I've informed the other side for the petitioner.
You are appearing for petitioner?
Petitioner, yes, my lord.
Yes. At
Day
the
after
request
tomorrow,
of-
my lord.
Not day after tomorrow, next week.
Next week, may kindly fix a date, my lord.
Yes, 22nd, yes.
Lord, serial number 56, if I may. Lord, I
50?
appear for the 56, my lord, I appear for the petitioner. I have informed the respondents. May seek one adjournment in this matter.
At the request of counsel for the petitioner, leave this matter next week.
Serial number
My lord, serial number 66, my lord. Serial number 66.
Yes.
I am petitioner, my lord. I request other side also, my lord. Next week, have it next week, my lord.
Leave this matter after 2 weeks.
66, my lord.
Yes.
For the respondent,
Yes, 26th, 26th.
Serial number 63, my lords. For the petitioner in this
63, my lord, I have an objection, my lord. I have moved this matter and they taken a time saying that their senior is not well. This is matter where covered with pleasure of the government, my lord. He doesn't have any right to file this writ petition.
Yes, yes.
I'm ready. We filed an objection.
ನಂದು ಪೋಸ್ಟಿಂಗ್ ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀನಿ.
ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ರೆ ಸರ್ವ್ ಮಾಡಿದ್ದೆ.
ಸರ್ವ್ ಮಾಡಿದೀರಾ?
ಹಾ ಸರ್.
Yes, 24th, yes.
Serial number 81, my lord. Serial number 81. I am appearing for the appellant, my lord. Kindly 1 week time may be granted, my lord.
81,
my lord.
Lord, any date may be fixed. Appear for the respondent.
You are for the respondent.
I am appearing for the appellant.
At the request of counsel for the appellant, leave this matter after 2 weeks.
My lord, serial number 67, my lord.
67.
On the respondent number 1 in this case, I informed to the other side also. I placed 2 weeks time, my lord.
At the request of which?
I appear for the petitioner that
Number 1, my lord.
Yes.
67, my lord.
Number 1, my lord.
May be fixed, my lord. Some documents have to be produced by the respondent.
Yes, 25th. Yes.
My lord, serial number 62, my lord, I pay for respondent 4, contesting respondent. I have informed the petitioner as well. There's some inconvenience, I seek 2 weeks.
Yes.
A date after 2 weeks may be fixed.
For the respondent, leave this matter on 26th.
Please.
My lord, regarding guest faculty matters, party in person, for asking for continuation, fresh matters, fresh matter.
Fresh matter. Yes, 23rd. Yes,
23rd.
Thank you.
On behalf of
submit so much. What is that?
Guest faculty posting limits, fresh matter.
Fresh matter, 23rd.
Yeah.
What is that urgency, madam?
You are here, right?
Yes, 25th, yes.
Serial number 52.
52.
Appear for the petitioner.
Appearing for respondent number 2 to 4, my lord.
You are appearing for?
Yes, petitioner.
Yes.
Request for an adjournment.
At the request of counsel for the petitioner, leave this matter after 2 weeks.
My lord, fresh matter, my lord. Fresh matter.
Fresh matter?
Yes, my lord.
Yes, tomorrow. Fresh matter. 39. R4. Yes, memo for retirement filed by the respondent number 4. We'll see when the matter is.
My lord, serial number 6, matter has to be connected with another WP. I'll write the number.
You are appearing for?
Petitioner.
Huh?
Petitioner.
Petitioner. When do you want?
My lord, any convenient date. It has to be connected with another writ
No,
petition.
what is that connected?
My lord, arising out of similar.
No, is it notice is issued in that?
Lord, I'm not aware.
Then how can you say that unless it is, matter has to be, notice has to be issued in this, still it is for an admission. We'll see. Yes. One time.
Yes, my lord.
Yes, at the request of petitioner, leaves this matter next week.
Sir, adjournments if any, list number 1 in VC. List number 1 for being spoken to, serial number 1, Vijay Kumar for petitioner, MS Narayan.
Lord, the judgment, my lord, which is passed on 20th August.
Yes.
I request my lord to kindly see the page number 7 of the judgment.
Yes.
One Jagdish R, my lord, who is the graduate. My lord, another name is reflecting, my lord, who is diploma holder, my lord. He is not similarly situated to the petitioner, my lord. Therefore, only Jagdish name may be, my lord, carried, my lord, and Kumar AS may be deleted. And annexure T1 and T2 are the documents, my lords, by which, my lords, the Jagdish R is got promoted. Annexure T1 and T2.
Not T.
Not T, my lord. T1 and T2.
Yes.
And, my lord, in the order portion.
In para 7, in page 7. The name of one Sri AS.
Kumar AS.
One Kumar AS has to be deleted. And annexure has to be corrected as T1 and T2.
T1 and T2, where Jagdish is got promoted, my lord, who was similarly situated to petitioner.
T1 and T2, that's all.
Yes.
Yes.
And in the order portion, my lords, at page 17, my lord, the impugned endorsement is quashed. And point number C, my lord, the respondents are directed to consider the case of the petitioner for promotion to the post of junior engineer from the date her juniors are promoted.
That is typographical error.
Yes,
It is there in that dictation.
Yes,
They
ma'am.
have left out.
Yes,
That will
ma'am.
correct it. Yes. Promotion to the post of junior engineer from the date the junior has been promoted.
Her junior has been promoted. Consequential benefits may also be
C,
ordered, my lord.
in C. That's all. Consequential benefits.
But I
are
have
not
sought, my
ordered.
lord, my prayer is specific
I
on
have
that
not
aspect.
ordered. That is there.
Lord, they may, Lord, further, Lord, they may, Lord.
For that, you file in a review. This is there in that.
Because Lord,
dictation,
seniority and all has to be reckoned from the date her junior has been considered.
That is the law. If they are not given, then you approach. On that day also, I have made same.
Please, Lord. Grateful to you.
Yes.
Preliminary hearing, serial number 2, SC Biradar for petitioner.
I appear for the petitioners, your lordships. So this was a maintenance matter between petition number 1 and respondent number 5, your lordships. Respondent number 5 works as a second divisional clerk at Kollegala Tahsildar office, your lordships. What has happened, your lordships, is the petitioner and respondent have been separated, but they have not been divorced. The petition number 1 files a application for maintenance under 125 in the year 2015, your lordships. Thereafter, in 2019, the Honorable Court in Kollegala, JMFC, orders for a maintenance of rupees 12,000 per month. Your lordship, thereafter, the respondent 5 has not been paying any maintenance, your lordships. He's been avoiding and
go and execute that order.
Your lordship, there have been criminal miscellaneous filed each year, your lordships, but the same has not been paid because there at this point there are.
No, 125 you can be executed before the criminal court.
Lordship, the warrant has not been issued, your lordship. So what?
Then, we are not here to execute that order, Mister.
Your lordship, what has
There is
happened?
an order, you go and execute there.
Your lordship, kindly turn to page 40, your lordships. The Honorable Court has ordered for attachment of salary, your lordships, 1/3 of the salary of the respondent number 5. Thereafter, your lordships, the same has not been executed by the.
You go and ask that executing court, Mister.
Your lordship,
If they are attached, if you have not done it, they have a procedure there.
Your lordship, we have filed for that, your lordship. We have been seeking directions because what they tell us the.
If they are not done executing court, you are remedy before some other court, not before me.
Your lordship, but the order has been made by the court, your lordships. But thereafter, what the nodal officers are saying is the salary cannot be deducted from his account and given you.
That is that executing court has to decide whether salary can be attached. If it is attached as a family pension or that maintenance, that will be executed. You can't come here and read petition, Mister. You go and execute that order. There is a remedy provided there, Mister. If they are not done, then you seek for a direction from that this thing.
Your lordship, we have sought, your lordship. They reply that there is no such provision to provide one third of the salary. If your lordship may kindly see page number 14, your lordships. Annexure number 14.
Yes,
Annexure C, your
in
lordship.
this writ petition, petitioner seeking for execution of the order annexure E. Annexure E na? E to L. Yes, execution of the order passed by Principal Civil Judge JMFC Kollegala in criminal miscellaneous 357 of 2015, filed under section 125 of the CRPC. To that effect, writ petition is not maintainable. Petitioner has an alternative remedy. Petitioner has a remedy under that. See, 125 is executing under 125 provision. In which provision the for execution has been filed?
The execution have been filed under.
Seeking for a execution of that order before appropriate court. Hence, writ petition.
Your lordship, there have been arrears application filed. Your lordship.
Executing. Now you are making me as an executing court. Yes.
Serial number 3, Shauri HR for petitioner. Government advocate.
Yes.
In this case, the petitioner, my lords, is a graduate with BSc, my lords.
Yes.
And MSc and BEd.
Yes.
She was working and a post, my lords, in a government aided school, my lords. Her post, she attended the interview.
Yes.
And she was selected, and her name was submitted for approval to the department.
Yes.
On though interview panel constituted by the department has interviewed her, she being meritorious, she was taken.
Yes.
While confirming her appointment for aid. My lords, they have raised an objection. In fact, 2 objections were raised. The one objection is not relevant now because now the government has withdrawn such a objection by way of a government order. But the other objection is that for a teacher to be appointed in a high school, in the subject of, CBZ, chemistry, botany and zoology must have been read out of at least 2 subjects out of which must have been read.
Yes.
And chemistry is mandatory. The petitioner has studied biochemistry in BSc.
Yes.
Biochemistry BSc, she has even for B.Ed in CBZ she was admitted.
Take notice. Yes.
Our objection hakagide.
Notice
agide, objection hakagide.
The question is relating to equivalence of biochemistry and chemistry, my lord.
In PUC, my lords,
Private party notice agilla.
private party a school on yaru illa
Only
sir.
the private party.
No private parties.
No private parties.
ತೋರಿಸಿದೆ ಸರ್ 4 to 6 notice not.
Alla 4 to 6 are government.
Government, yes, government advocate is directed to take notice.
They have even
Notice
filed
agide.
objections, my lords.
Notice agide, statement of objections.
The SO is also filed.
4 to 6 you have not taken notice. Government advocate is directed to take notice for respondent number 4 to 6. Please this matter in B group. Yes.
My lords, because it is going on, my lords.
Yes, we'll hear on B group.
Okay, my lords. One more submission, my lords. They have issued, though they have returned my file, subsequently, recently, they have issued an endorsement to me stating that my application is rejected. Hence, my lords, I have filed an application. I am filing an application, my lords, the court permits, seeking amendment in the prayer, my lords. To
Government advocate is 1 to 3. Yes, 1 to 6 you are taking notice. We'll post it for B group.
on the application,
File it in that counter. In the meantime, yes.
a date may be given, my lord, because there is urgency in the matter.
25th. Yes.
Much.
You have filed an objection.
Agide, sir.
They have already filed.
Yes.
Limited question, my lord. Equivalence of biochemistry and chemistry, whether it is not there or not.
Serial number 4, Tyagaraja S.
Yeah, for the petitioner in this case, my lord. The petitioner is working as a daily wage employee under the respondent number 5, my lordship. He is working in the department and daily wage, my lordship, on 1st November 2019, 87. The date of birth of the petitioner is 5/10/1967.
67.
1967. In all certificates, my lordship,
Where you are working?
under the 5th respondent, my lordship, now I am working. So the service certificate, my lordship, I have given the affidavit and also along with all the documents, my lordship, to substantiate as I am date of birth is 5/10/1967. But my lordship, provide annexure E in service register, my lordship, page 19, my lordship. Then date of birth has been overwritten by the government, my lord, the respondent number 5,
No, you are working in that forest department.
forest department.
And then you can go to that KT.
Lord, even my
daily
lord,
wage employee.
he has to approach the civil court, my lord. He has to correct it in the initial stage only. So he did not do that. He has to
Now
approach
3 years is over. What is the endorsement they have given?
Endorsement given, my lordship, on 31st January 2025 by annexure G, page 45. Wherein they have stated, my lordship, they have obtained a legal opinion from the concerned department, therefore they have rejected my claim.
Yes, anyhow.
By
you go to
my ground is, my lordship,
You go to that KT.
KT is a daily wage employee.
Yaak barala.
The change,
Daily wages employees cannot be approached KT.
the change of date of birth,
He is
my
a
lordship,
benefit,
so far as
he is a
concerned to
beneficiary
my,
under the 2012 literally.
my prayer is only in respect of, my lordship, change of date of birth, my lordship, that's all.
No, it is not depending upon the prayer, whether he can go it there or not.
Civil court go.
Not, no, that endorsement is issued. He has to challenging that endorsement. Yes, you have to go to that KT, mister. Yes. Internet, at outside, government advocate has raised an objection that petitioners is working as a daily wages employee.
Under the welfare act, my lordship, he is getting.
Correct, regular.
Welfare act already ille
What
barutte
has
anta.
happened, Lord, he is a civil servant.
Now that not a daily wages employee.
Not a daily wages.
Then
Yes.
how can you say that daily wages, mister? Yes,
Appoint-
petitioner.
Well, welfare act.
Yes,
Welfare act.
petitioner- Now he is working as what?
I am working as a daily wage earner, but welfare act ಅಲ್ಲಿ ಬರ್ತಾ ಇದೀನಿ ಅಷ್ಟೇ. First I was appointed.
ನಿಮ್ಮನ್ನ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಾಗಿತ್ತಲ್ಲ.
Regularize ಮಾಡಿಲ್ಲ ಇನ್ನು.
ಇನ್ನು ಮಾಡಿಲ್ಲ.
No, no.
How can you say that you are
ಅದರಲ್ಲಿ ಸೇವಾ ಭದ್ರತೆ ಕೊಟ್ಬಿಟ್ಟು they are not getting any benefit, but they will not be removed until 60 years ಅಂತ 2012 ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಅದು.
Yes.
But my claim is my lordship, ನನ್ಗೆ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಚೇಂಜ್ ಮಾಡೋದ್ರಿಂದ
ಆಯ್ತಲ್ಲ. Yes. Submitted that. Petitioners is holding in a civil post. He has to approach Karnataka Service Administrative Tribunal in view of judgment of apex court in so and so. The above writ petition is disposed of, reserving liberty the petitioner to approach appropriate legal forum if law permits.
Serial number 5, Prasanna Kumar P.
For the petitioner, my lords. Petitioner, my lord, is a retired construction worker who had applied for seeking pension. Now that pension, my lord, initially your lordship will find at page number 18, page number 19. An endorsement is issued by the government stating that, may I read, my lords, page 19.
Yes.
ಮಾಸಿಕ ನಿವೃತ್ತಿ ವೇತನ ರೂಪಾಯಿ 3,000 ಪಡೆಯಲು ಶ್ರೀ ಸೋನ್ಸೋ ವಿಳಾಸ ಸೋನ್ಸೋ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ನಿಮ್ಮ ಅರ್ಜಿ ಸಂಖ್ಯೆ 23/8/22 ಮೂಲಕ ಮಂಜೂರು ಮಾಡಿ.
Annexure E.
Annexure E, my lord, page 19 please.
ಮಾಸಿಕ
ನಿವೃತ್ತಿ ವೇತನ 3,000 ಪಡೆಯಲು ಶ್ರೀ ಪ್ರಕಾಶಾಚಾರ್ ಸೋನ್ಸೋ ಇವರು ಹೊಂದಿರುವ ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಮತ್ತು ಲಗತ್ತಿಸಿರುವ ದಾಖಲಾತಿಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದ್ದು ನಿಮ್ಮ ಅರ್ಜಿ ಸಂಖ್ಯೆ 23/8/22 ಮೂಲಕ ಮಂಜೂರು ಮಾಡಿ ನಿಮ್ಮ ಕೋರಿಕೆಯಂತೆ RTGS ಯೂನಿಯನ್ ಬ್ಯಾಂಕ್ ಶಾಖೆಗೆ ಜಮಾ ಮಾಡಿದೆ. They issued this endorsement to me, whereas the money did not get credited into my account. Thereafter, when I inquired, your lordship will find on page number 15, Annexure A, the last paragraph, my lord. ಸದರಿ ಅರ್ಜಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಫಲಾನುಭವಿಯಾದ ಶ್ರೀ ಸೋನ್ಸೋ ಇವರಿಗೆ ನಿಯಮಾವಳಿಗಳು.
It's in a labor matter. Yeah, it's a labor matter.
Construction code, it is come under the labor department.
We have to go before the labor service. Classification is wrong. Yes. You are
I'm a retired.
No, you are working in the wood industry.
Wood industry, please.
Registered carpenter. Registered carpenter.
Yes, you can go to that labor yes, office has wrongly classified as service matter instead of classifying as in a labor service antane irbekalva anta. Yes, office is directed to reclassify the same post before appropriate roster bench.
Serial number 6, adjourned. Serial number 7, Abhiraj B. Changti for petitioner.
I applied for the petitioners, my lord. My lord, there is an alternative remedy provided under section 130 of Karnataka Education Act, my lord. I am moving a memo for withdrawal, my lord.
Yes.
Liberty may be granted to file petition before the Commissioner Public Instructions, my lord.
Which is that order you are challenging?
Lord, Annexure K, my lord.
Annexure K.
At page 38, my lord.
K is, what is that?
My lord, this is.
Abhyartha Patti.
Yes, my lord.
130 alla 131 irbe.
131.
Yes.
Yes, because revision, it is not an order passed by the authority. Learned counsel for the petitioner has filed a memo. Leave of this court to withdraw this writ petition with liberty to approach appropriate legal forum under Education Act. The memo is taken on record. The above writ petition is disposed of. Government advocate to take notice. Reserving liberty to the petitioner to approach appropriate legal forum under Education Act if law permits. Yes.
Number 8, Narayan Bhatt mover for petitioner, BV Vidyulata.
Appear for the petitioner, my lord.
Yes.
This is pertaining to the timings, my lord, of the process servers.
Where is your opponent?
Last occasion also.
Password ಮಾಡಿ ಬರ್ತಾರ ಅನ್ಸುತ್ತೆ password.
No, last occasion also she is not.
The lordship has passed an order on the last occasion.
There it's there, none appear. Today it's not come, I will record it and. Yes.
230, my lord.
Password.
230, my lord, or?
Password after that list is completed. Yes.
Serial number 9, Muralidhar HM for
I
petitioner.
appear for the petitioner, my lords.
Yes.
My lords, the actual date of birth of the petitioner is
Yes.
31st of December 1964.
Yes.
But it was erroneously entered in the service records as 31st of February 1964. I sought change in the date of birth, but they did not agree. I unsuccessfully challenged that order as order in writ petition, and writ petition was rejected as per annexure yes, on the ground that you have sought change in date of birth at the fag end of service. All right, I accepted that order, and I was made to retire from service on 28th of February 2024. Now that my grievance before my lords is, I have applied for settlement of my terminal benefits. What they are saying is, you get your date of birth matched in your Aadhaar card and PAN card, which is apparently not correct. My SSLC marks card says I was born in December. My PAN card says born in December. My Aadhaar card says born in
Now
December.
you are seeking your pensionary benefit in terms of the service records, what it is.
Yes.
You are not seeking any.
No, I can't.
Yes.
That is a simple relief what I have sought in this writ petition.
Issue notice. Yes.
My lords, I may be permitted to take out notice on Mr. Dinesh Rao N, who appeared earlier for Food Corporation of India, my lords.
Yes. Learned counsel for the petitioner submits that he may be permitted to serve a copy on Sri Dinesh Rao.
Mr. Dinesh Rao H. N.
Dinesh Rao N. Yes. In addition, petitioner is permitted to serve a copy to so and so. Yes.
My lords, I will serve and come back on next Monday, my lords.
Not next Monday. You serve it. Let us see. After
Please.
that, yes.
Please.
Number 10, Vaishali Hegde for petitioner, A.D. Ramananda.
Yes.
Your Lordship, I have filed in the counter, an office copy, it may come later for the time being, I'm giving my copy
Yes.
regarding my appointment letter, everything related to.
Where is your appointment?
Your Lordship may kindly turn to page 6.
Yes.
This is my appointment letter.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ 15-16 ಅಲ್ಲಿ these are all the colleges which comes under the university, my lord.
Adu, even page 7, your Lordship may kindly turn to page 7. It is very clear that I'm an employee of Mysore University. Page 7.
Yes.
Page 7, it is very clear that I am an employee of Mysore University. And your Lordship may kindly turn to page 14 to 16, which clearly discloses that Maharaja College is a constituent college of. Maharaja College is a constituent college of.
Yes, madam, we have received that.
No, your lordship may kindly see, there is no denial that it is a constituent college. It's not a faculty in the university. That is the whole case.
Yes.
It's not a department in the university. Your lordship may kindly see, he is directed to page 6, which my learned friend is relying on.
Yes.
He is directed to report to the principal, Maharaja College, Mysore. There is Yuraja College.
Yes.
There are 5 colleges which come.
Yes.
It is not a
University
department
Act.
of the university. May I just,
No, faculty should be in that university, Mr.
University.
Government Advocate.
Lord may make one
If that
submission, Lord.
section says,
Lord,
one
page
should be an
27.
employee of the university.
ಹೌದು. Place 27, it is not disputed that he is an employee of the university. That is what it requires, Lord, is all professors and in the absence of professor, reader, so and so, so and so.
let my learned friend file an affidavit.
No,
The-
register shall be a whole-time officer of the
Howd.
state
Yes.
government may appoint an officer of the Karnataka administrative service not below the rank
The
of.
whole
group
Lord, that
A,
is 18, my lord.
A senior member of the faculty of any university to be a register evaluation of the university.
Your Lordship, the petitioner here also has come from the same jurisdiction. He was working
Just
and
wait,
then.
wait, I will hear. Yes.
Lord,
Senior member of the faculty of any university means what?
ಹೌದು. May make one submission, my lord. Now, page 25 of the writ petition, there is one judgment, my lord. They have referred all the provisions of the University Act, my lord.
25.
ಹೌದು ಸ್ವಾಮಿ. Page 25 ಅಲ್ಲಿ judgment ಅಲ್ಲಿ,
Hmm.
that is section 3 is department.
Yes.
Petition ಎಲ್ಲಿದೆ?
2-3, my lord. What is the department means, my lord? The Department of Studies, Post-Graduation Department and Postgraduate Department Studies means the Department of Study, Postgraduate Department and Postgraduate of Study in the university run and maintained by the university, my lord. That is one aspect, my lord. Section 18 also called out, my lord. What is that? That is senior most, my lord. That is not, I am not disputing that. Next page, ali para 6, ali 34, that is the qualification is required faculty, each faculty.
Yes.
Reads under each faculty consists of following members, namely,
Page.
page 27 ali, next page.
27.
Para 6. My lord, each faculty shall consist of following members. Dean of the faculty, that is not disputed, my lord. Chairman of the department, study and faculty. All the professors and in the absence of professors, reader of the faculty of each department and faculty. My lord, even though this college is a constituent college, my lord, that is my understanding, my lord. What
You have to say what is
Yes.
that meaning of that
Yes.
Universities
That
Act.
is
that,
not
my lord,
required.
that has to
Your
be
understanding, you have to say.
whether
That word they are used is senior member of the faculties of any university to be a registrar of the university. Senior members of that faculty.
Lord, now the question
Yes,
arises,
professor
Lord.
or in the absence of the professor, reason of the faculty from the each department of, it is different.
If I may, your lordship, just to save the time of the honorable court, I have just forwarded a set of documents. My,
Yes.
with respect to my, the learned government advocate, it should be, all this should be put down in affidavit. His opinion
That is
is
not
of
given, Lord.
Your
That
lordship
copy
may
is not
kindly see
served at me.
page 75. This is the seniority list of the professors in the university.
Yeah, that's
The
what, there
university.
he should be there.
Yes. Now your lordship may kindly see page 83. This is the seniority list of the professors and other teaching staff in the constituent colleges.
Yes.
And your lordship may kindly see the last bracket. Not one of them, the present respondent stands at page serial number 63. That's another thing they'll have to explain. What was the exceptional qualification that he had, that he overtook 63 members to become the registrar evaluation.
Yes.
Your lordships may see the last column. Not one of them have been appointed as dean or registrar.
Yes.
Now your lordship may take the seniority list at page 75 of the of the professors of the university.
Yes.
It's the the writing is a little small, I can.
Yes.
All those are markings, your lordship, of persons appointed as registrars in various universities or as dean
Because he is a full-time officer
of the university.
Among them, they will.
I'll
select
make
it.
my submission to what she has referred. A person who seeks equity must come before equity. First of all, what is, your lordship may kindly turn to the petition filed by the thing, is he was till 2019 working in ordinary college. 2019, he came as a professor to the university.
So ordinary
Whereas-
college. Ordinary.
Before she says that I am the senior most and see that contention, within 2019, he was appointed as a professor and within,
Yes, let the
and
government.
there are certain,
You
the
file
government,
your objection, Mr.
and,
Yes.
and
We'll hear that matter, yes.
in the meantime, your lordship has heard this matter at length, where she was the author earlier and I am NOC,
that is
I
irrelevant.
come on NOC on record. And our three contentions, our first contention is, I am not a member of university, that I approved that I am working as a thing. Second contention is, she says that doctrine of pleasure. Third contention is bringing natural justice. The judgment relates, the petitioner worked for 2 years, 1 month. That this court in Krishna Dikshit judgment and Shyam Prasad said 2 years is the term. Now he has exceeded.
For I am here, I will hear that matter finally. You file an objection.
And
Your lordship,
we will also file our compilation on
Yes.
this.
Now,
And
that's only a point that whether he should be in the faculty of the
Employee who is
university.
under the
Another
constituent
thing,
college.
this issue of 2 years, I have no idea where they're getting this 2 years. His lordship has said, in one case it is 1 year, in one case it is 4 years. Perhaps a balance could be struck. There's no prescription of 2 years, either in a judgment or in the statute. So why my learned friend is going on about the 2 years, I don't understand. It is that, it is
Lordship,
1
that-
minute.
For that
When
reason,
I
it
am
was
on my
argued
feet-
on length with senior counsel, that aspects, compilation is being filed, and it may be tagged with 148.
No, there's no question of tagging, each question.
And
each
I
case
have
is-
no objection, let it be tagged, because the issue is same. It may be tagged, it is reserved for judgment.
Yes.
ಅದೊಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದ್ರೆ ಅಂದ್ರೆ
Free, you file an objection. Government advocate is
And
directed.
I may be permitted to file my compilation for what? See, the
Government
person,
is directed to take notice for respondent number 1. Who is there for university?
Lord, the university, Mysore University. Mysore University.
Kuvempu
I-
University. It's a Kuvempu University.
Who was that? Earlier was.
You will
Of
take
course, Sunga
Rajendra.
idhare, Sunga
Yes,
idhare.
Rajendra Sunge is directed to take
Sunge.
notice. So and so is government advocate is directed to file. You also file objection, mister. Whether he is in faculty or not, he is the right person to say.
Please, exactly.
1 and 2 is directed to file statement of objection within 2 weeks.
The other compilation.
I don't copy code you.
I'll give the copy, Your Lordship. Your Lordship may have it next week, Your Lordship, because he's taken charge and he's enjoying a post which he shouldn't be.
Therefore, that now I can't.
even
grant
I will
any
make the
interim order.
submission
Finally,
that
it is-
there are certain accusations against him of.
Now, see, it is not that petitioner. Only thing is, if you go out, she may there for some time because it is in a pleasure, doctrine of pleasure. She can be removed at any time.
That is, she's been removed, the person is removed.
But whether she has been replaced by a proper person or not is the question.
Absolutely.
That question I have answered in my statement of objection.
Answered, I have seen that. Yes, I have seen that. Yes. Therefore, I want government to be explained. Yes.
Your Lordship, in the
I may be
meanwhile,
permitted also to file my compilation.
Yes, yes.
in the meanwhile, will your Lordship consider an interim prayer?
Now,
I
inter-alia
strongly
only-
oppose. If
Yes.
the same case I was not given interim order.
Yes, we'll file that. Anyhow, you have taken that charge. Only thing is, I can say if he is not taken charge, interim order, but he is already taken charge.
Taken charge.
Let us see. that. Yes, you file objection. Yes.
Cell number 11, Srinivasake.
Petitioners of the retired employees, my lord, they are eligible for sanction of increment for the last year of service
Yes.
in terms of the judgment passed by the Istanbul court at Annexure F, my lord. Similar cases, my lord, the respondents have granted the order, passed the orders and sanctioned the increment Annexure
Who is
J and
appearing
K.
for respondent?
Chandrachud, my lord, has appeared for the
Prachud is directed to take notice for respondent number 1 and 2. Counsel for the petitioner is directed to serve 2 sets of copies.
public.
Cell number 12, Ajay Prabhu M for petitioner.
My lord, in similar matter, my lord, this honorable court has already granted stay. Guest
what is
faculty matter, my lord. Guest faculty matter, where my lord, these, the petitioners were, my lord, substituted by another set. Where they were working in 23-24, my lord. They have been, my lord, till half of 24-25 academic year, they have been working. You know, in the middle of the academic year, they have been removed. My lord, I'm seeking for continuation of their.
No, if they are removed, if there is no workload,
No, my lord, that is not the case, my lord. There is no
have
change.
they replaced you from anybody?
My lord, it is same, my lord, same, yes, my lord. Election, moreover, my lord, that the committee is formed to, my lord, on the representation of some of the co-workers. That the finding of the committee was, my lord, that the selection is not held properly and transparently.
No, now you have been appointed for academic year, that is over.
23-24. Thereafter, my lord, I have been continued on the, my lord, request of the director. Till half of, my lord, 24-25. They themselves say in the next area, my lord.
No, if they don't have any workload, we can't ask them to continue, mister.
My lord, there is, my lord, I would, last occasion, my lord, similar matter demonstrated, my lord, there is violation of workload, my lord, where after the workload is.
Two things. If they are replacing you by another set, then you have right.
Yes, my lord.
If they want to continue, then there should be a workload.
Lord, other than me, my lord, everybody else is continued.
No, that is what that, it is depending upon the workload.
My lord,
If there
workload
no
is
work-
not changed, my lord. There is no new syllabus is introduced.
We'll say that if there is a workload, they can be continued.
My lord,
Yes.
that is what, that last occasion I demonstrated, my lord, please to grant interim
Demonstrate
order.
each case.
Lord, same, my lord, same case, same notification. I have challenged.
No, here, the petitioner, each person has different subject.
No,
If
Lord,
there is
this
any
is
workload-
pertaining to, my lord, the same subject. Same subject.
No, if there is a workload, then only we can continue.
My lord,
You show me that workload, how many teachers are there or not? Yes.
my lord,
Issue notice.
my lord, last occasion, my lord, I have shown that, my lord, in
No,
same matter, my lord,
no,
same matter.
No, you can be continued only if there is a workload, is it not?
My lord,
Are you
I have
agreed or not?
I understand, my lord.
Then I am saying that if there is a workload, continue the petitioner not to relieve from the service. If there is no workload, nobody can be continued, Mr.
My lord, I have not been given reason, my lord.
No, then it
Kind-
shows
kindly-
that.
kindly, my lord, one
No,
submission.
it shows that there
One
is no
submission.
workload, still he wants to continue.
No, my lord, one submission. My lord, they have to call it in, my lord, 24-25. My lord, I've been continued for a half of that academic year, my lord. My lord, same workload will be continued that for whole, my lord,
No,
year.
see, if there is any workload, if they are not, they can't replace anybody, they have to continue.
No, my lord.
They can't
I've
replace.
worked till half of that academic year, my lord.
Yes.
My lord, kindly, my lord, appreciate this, my lord. I worked till half of that
Therefore, I am
academic
saying
year.
that if there is any workload, you have to continue.
That's what.
What do you want then?
Yes,
Then we'll give the notice to them, let him come and.
No, my lord. My lord, I understand. I'm sorry, my lord.
Yes. Third issue notice. Government advocate is directed to take notice for respondent number 1.
Lord of the
University Grant Commission, who is there?
Shauri, sir.
Register, which university, Mr.?
Bangalore, my lord. BR Prasanna appears for.
Who is appearing for?
BR Prasanna.
Huh?
BR Prasanna.
Prasanna is appearing for respondent, directed to take notice for
3 to 5.
3 to 5. The respondent are directed not to relieve the petitioner, are directed to continue the petitioner in the service if there is sufficient workload till next date of it.
If not already relieved.
No, he is already relieved. But if there is a workload, you have to continue. Yes.
May I make request, my lord? My lord, the last occasion in the connected writ petition, they have given representation to take them back, my lord. This what they say is, my lord, there is no time frame fixed by the court.
No, why are you mixing all these things? I said that if there is a workload, you have to be continued.
In the earlier writ petition also, my lord, if the workload is also there, they will not take me back without fixing the time, my lord.
See, if there is a workload, if they are not taking back, you convince me, then I will direct it to take that.
Please
Show me now that there is a workload. Yes, yes, yes.
My lord,
Let them.
the
let
proof
them
itself
take-
is, my lord, that they have continued for half of the academic year. That is
Yes,
the proof, my lord.
Yes, yes.
In the midway, my lord, the syllabus will not change, my lord.
Yes,
Serial number 13, Chandan Gaud Patil for petitioner.
yes.
It's appearing for the petitioner in this matter. In this matter, we have challenged the appointment of respondent number 5 to the post of process server, she has been appointed in the court of small causes matters. We are challenging her appointment on the same ground.
Similar matter yesterday.
Please, matters.
That Vivek has taken notice.
Please, matters.
Yes.
I may be permitted to serve respondent number 5 through hand
Government
summons.
advocate is directed to take notice for respondent number 1 and 2. Vivek, Vivekananda is directed to take notice for 3 and 4. Issue emergent notice to respondent number 5. Counsel for the petitioner is directed to serve 2 sets of copies on government advocate and 2 sets on Vivekananda TP. In addition, petitioner is also permitted to take out hand summons to respondent number 5.
It may be tagged along with the
All this matter along with.
29418 of 24.
Yes.
Dispensation, sir.
Grateful.
Dispensation period of 4 weeks.
Number 14, Nayanatara PG for petitioner, Girish Kumar R.
Yes.
We are on behalf of the caveat.
Yes. Yes, Mr.
Lords, kindly have a look at page number 20, just 2 sentences before that.
Yes.
Lords, the present petitioner has served for about 23 years in NAAC.
Yes.
Lords, this is the National Accreditation Council.
Yes.
And the post of director is a tenure post where on selection some person will be appointed as a director for a period of 5 years. That's it. Now, the present director, who appears to have chaired a meeting on 13/8/2025, had some grievances about my conduct in that meeting,
Yes.
which results in a show cause notice issued by the director at page number 20. Very interesting.
Yes.
This letter is to inform you that this officers received your email dated 18th August.
Page 20.
Lords, page 20.
Yes, yes. Yes.
Lords, I'm sorry, Lords, may kindly see Annexure A, page 18, show cause notice. Page 18.
Yes.
It has been observed that you have been behaving inappropriately in the meetings by passing sarcastic comments and jokes, arguing with the chair andre director, critically commenting on policies, etc. You have been advised several times not to repeat such behavior and to maintain the official decorum. At yesterday's meeting, that is on 13/8/25, you did not follow the timings and were not attentive to the discussions. You were pointed out a mistake politely and were advised to be serious in the meeting. However, you had raised your voice and behaved completely unparliamentary and disrespectful against the chair in the presence of the officials in the meeting, bringing down the dignity of the position of the director of NAAC and also to the individual. Further, while the director was leaving in the meeting, you have threatened the director with retrograde words. I really do not know what it means. Anyway, these acts, as indicated above, committed by you amounts to serious misconduct, which would warrant serious disciplinary action against you. You are hereby required to show cause within 4 days of the receipt hereof as to why the disciplinary action should not be initiated against you. Should you fail to submit your explanation as required, it will be presumed that you admit to the charges and have no explanation to offer, and therefore the matter will be referred for further action. But I'll just pause here. The receipt of this letter should be acknowledged. Next line, this has the approval of the competent authority. This is issued by the administrative officer.
Yes.
Not just on the show cause notice, I got 2 submissions to make. The administrative officer is appointed by the board. Notice the board is the competent authority under the bylaws itself, that the appointing authority will be the disciplinary authority.
Yes.
So notice for show cause also requires to be issued by the competent authority, which will be on the approval of the board only.
Yes.
I'm making a statement, and the statement is made saying that there is no board meeting which has been convened, because I'll also be a part. I'll know whatever is happening.
Yes.
Never any board meeting has been convened after 13/8/2025.
Yes.
So this is the administrative officer who does this.
Yes.
Our specific contention is that there is no preceding board meeting on the basis of which this could have been done. I'll take your lordships to the bylaws a little later. Lords, I give a reply, my lords, which is at page number 64, but I'll not trouble your lordships with the reply. Then comes page number 20, suspension order. My lords, first your lordships may kindly see who has passed this order of suspension. 2020, Annexure B.
Yes.
Who has passed this order of suspension? Director.
Yes.
The entire allegation against me is that I have disrespectfully conducted myself against the director, and director would issue an order of suspension against me. Whether this could be done is one aspect of the matter which I'll canvass, but now your lordships may kindly see the contents of this letter.
Yes.
This letter is to inform you that this officers received the email dated 18th August in response to the show cause notice of 14th in connection with your misconduct in the workplace in the recent past. Your explanation for the show cause notice is not satisfactory at all in all respects. Anta yaar heltirodu director. Adukku mundukku hogtini ಏನು ಅದರದ್ದು significance ಅಂತ. NAAC takes any violations to fundamental values like respect and dignity of the official position and the individuals maintaining office decorum and use of improper language very seriously. Unfortunately, your behavior in the recent past, especially in the meeting of 13/8, did not portray the core values of the organization at any workplace. Your misconduct was said to be disrespectful and unparliamentary towards the director of NAAC. Avun mele matra takrari irodu, which is not permitted within our working environment. As per the provisions of clause 5.6 of the bylaws, accreditation council, it is informed on 29th of August, you are placed under suspension from your position as advisor pending further inquiry.
Yes.
Anta madidru. Iga, during the suspension period, you will not be allowed. So, I will not trouble your lordships on this. Now, if your lordships were to take page number 34, there is a constitution of the executive committee.
Yes.
This is the board which I was referring to. Lords, and then if your lordships were to take the bylaws at page number 43, That's, I just wanted to bring to your lordship's notice, that's a very big, large body. Executive committee ಅಂದ್ರೆ 14-15 ಜನ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ. ಇದರಲ್ಲಿ ಡೈರೆಕ್ಟರ್ಗೆ ಮಾತ್ರ ತಕರಾರಾಗಿದೆ ಅಂತ ಹೇಳ್ತಿರೋದು. ಬಟ್ ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಬೇಕು ಅಂತ. If your lordships were to take clause number 5.1 at page number 54.
Yes.
The appointing authority referred to hereinafter as disciplinary authority of the NAC can take disciplinary action against its employees for misconduct, misbehavior or breach of the terms and conditions of appointment, and can impose with major or minor penalties on the employees, so on and so. Then 5.2 is the disciplinary procedure.
Yes.
Notice, I'll just pause here. So far as this post is concerned, if your lordships were to take the appointing powers, notes at page number 49.
Yes.
Note, this is a group A post. At clause 4.1, appointing authority for group A post is the executive committee.
Yes.
So now I am holding a group A post.
Yes.
There is an allegation against me that I have been disrespectful to the director.
Yes.
Executive committee, under by virtue of the powers under clause 5.1, will be the disciplinary authority. Now, when can an order of suspension be passed is the question. Then who can pass? I will also address that. Clause 5.6 at page 56. First I will address when it can be done, then I will go to who should do it.
Yes.
Page 56 at clause 5.6. The director may suspend an employee. Lordships may kindly mark the next phrase. Pending inquiry or investigation of the allegations of the misconduct against him or her, or where disciplinary action against him is contemplated or is in progress, suspension shall not be treated as a punishment. Now, there are three contingencies under which it can be done. There is a pending inquiry or an investigation by the disciplinary authority. It will be only by the disciplinary authority. Two, there is a disciplinary action or it is contemplated. Either of it. That means there is already an inquiry or investigation, disciplinary inquiry is contemplated, or the disciplinary action is already under progress. All these four things is a decision to be taken by the executive committee. Unless the executive committee takes a decision to initiate disciplinary proceedings, initiate inquiry, or initiate any investigation on the allegations which is made, 5.6 itself does not crystallize to exercise such powers.
Yes.
Number one. Now, in furtherance of what's this statement, if I were to just draw your lordship's attention to page number 20, which is the suspension order, it says pending inquiry. Inquiry yavude pending go. There can be three contingencies. The authority executive committee may say we are contemplating to hold an inquiry, or the suspension order may say that in contemplation of the disciplinary proceedings being initiated or an inquiry being held, you are kept under suspension. That is permissible under clause 5.6.
Yes.
Reason is, I am not satisfied about your reply given to my allegations against me. Therefore, I want to place you under suspension for the reason that your conduct is reprehensible. That's essentially what the director himself says. So the reasons which is assigned in the order at 20 and what has been spelled out in clause 5.6 will indicate that until and unless the executive committee starts the process, the power of suspension itself will not crystallize to the director for the purpose of exercising the same. In other words, no power to exercise the power of suspension. Absolutely lacking in jurisdiction.
Yes.
Number two, allegation is director is the person who is going to be the witness. Because it is he says, no, there is some disrespect to me. He may or may not be a witness, but he is directly connected with the allegation in respect of which the suspension is caused.
Yes.
Directly connected, or he is the only person who is connected.
Yes.
The executive committee has not dealt with this issue at this point of time.
Yes.
Whether he can say it's an apparent bias, forget about apprehended bias.
Yes.
5-year term director, I am a 23-year-old employee who has come up to the ranks. Now what happens? I am already under, I have already submitted a representation seeking for VRS 6 months back. They are just holding it back for some reason. We don't know why they are holding it back. They could have relieved me. I would have walked out. God knows what they are trying to dig about against me. Now they found that this is the occasion for them to do something. But fact remains, he is sitting as a judge of his own cause. An order of suspension has to be preceded with some application of mind. It is not that in all cases,
Yes.
where there is a disciplinary action pending or inquiry pending, that in all cases there is going to be an order of suspension. That is never the law. It should warrant the passing of an order of suspension because continuing him may in some manner affect the investigation, inquiry, disciplinary proceedings. This is how the law has originated. But this director, he himself passes an order of suspension because of this reason. May I just rely upon one judgment, my lords, of the Honorable Supreme Court. What's a Constitution bench had an occasion to deal with this issue. What's more or less a similar fact situation.
Yes.
What's in this case, the change is that the disciplinary authority himself was the person against whom the allegation was there. Here we are dealing with the order of suspension. The principle in service law remains the same so far as apparent or apprehended bias is concerned. Notice the Honorable Supreme Court, after considering, if your lordships were to see at page number, at paragraph number 5,
Yes.
the last paragraph.
Yes.
Last 4 lines from the bottom. Evidently,
Yes.
respondent number 3 assessed the weight of his own accusations against the appellant and passed a judgment which is one of the easiest to pass, namely that he himself was truthful person and appellant is a liar. In doing this, respondent number 3 violated the fundamental principle of natural justice. Main thrust of the charges against the appellant related to his conduct qua the third respondent. Therefore, it was not open to the latter to sit in judgment over the explanation offered by the appellant and decide that the explanation was untrue. No person can be a judge of his own cause and no witness can certify that his own testimony is true. Anyone who has a personal stake in an inquiry must keep himself aloof from the conduct of the inquiry. Order of dismissal passed against the appellant stands vitiated for the simple reason that the issue as to who between the appellant and third respondent was speaking the truth was decided by the third respondent himself. That's essentially where we stand. If your lordships were to just have a look at page number 20 once again, he says, I am not satisfied with your explanation. Page number 20, the first paragraph.
Yes.
The letter, this letter is to inform you that this office has received your email of 18th August 25 in response to the show cause notice in connection with your misconduct in the workplace in the recent past. Your explanation for the show cause notice is not satisfactory. Even director. ಇದು ಆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ನಲ್ಲಿ ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನೋಡಿದ್ರೆ ಅದು ಅವರಿಗೆ ಆಗ್ತಿಲ್ಲ ಅಂತ ಗೊತ್ತಾಗತ್ತೆ. ಆ ಪೇಜ್ 18 ಅಲ್ಲಿ ಇದೆಲ್ಲ ಪರ್ಸನಲ್ ವೆಂಡಟ. 23 years of unblemished service, 5 years tenure director. So therefore, my lords, this is not a matter where they can keep me out of employment. That's what we said it.
Lord, now, your lordship may kindly see the reply notice at annexure F, page 64.
Yes.
Lord, your lordship may kindly turn to annexure F, page 64.
Yes.
My lord's got it.
Yes.
Your lordship may kindly see the subject.
Annexure A.
Annexure F, page 64.
Yes.
That is their reply notice to the show cause.
Yes.
Your Lordship may kindly see the subject. Reply and request for reconciliation measures to protect dignity at workplace.
Yes.
For reconciliation, that's what they're trying to seek. Then your Lordship may kindly come to page 65
Yes.
and unnumbered para 1, 2, 3, 4, fifth one in the middle.
Yes.
It's painful and difficult to understand how such contributions could become irrelevant in a spur of a moment. That what's happening in a spur of a moment, what he has said.
Page.
Page 65.
Para.
Para, if your Lordship sees the last para,
Yes.
not the one before the last para, only 2 lines there is one para, unnumbered para.
Yes.
It's painful and difficult to understand how such contributions could become irrelevant in a spur of a moment. So his contention was that in a spur of a moment, he does not dispute as to the unparliamentary words used. He probably says that it was on a spur of a moment, so I've used those words. So he's not disputing that. Then your Lordship may kindly see second para, the last para.
Yes.
Mentions a one-sided version of an unfortunate incident. So he himself says it was an unfortunate incident.
Yes.
That happened during a meeting on 13th August 2025. A balanced version or other side could describe the incident as a heated exchange with tempers running high.
Yes.
I would once again say that I was saying that day and I was extremely unwell and upset. So he's trying to say as to why. And then summary and request. That's on page 66.
Yes.
Page 66, my lord.
Yes.
Your Lordship got summary and request.
Yes. Yes.
Your Lordship may kindly turn to page 66.
Yes.
Last but one para, summary and request in bold.
Yes.
He's himself made it in bold and said, after this incident,
Yes.
I immediately tried to connect in an attempt to heal the pain on both sides and remove misunderstandings. As of today, I would again submit that I'm hopeful that the root cause of such incidents, which is perhaps misunderstandings and trust deficit, needs to be discussed. Now, my lord, I'll just pause here for a moment. And my lord, the judgment of the Constitution bench of the Supreme Court, my lord, I have absolutely no quarrel with that. This is with regard to a dismissal. That's why they say that with regard to a person who cannot be a judge in his own cause. This is not a case of dismissal. This is only a case of suspension as to what has happened. That now inquiry, that will be done again by the executive committee. They will proceed with the inquiry. That also, that decision will be taken. Now he has been suspended for a period of 3 months. Now they'll, and the 5.6 says, page 56. The director may suspend any employee pending inquiry or investigation of allegations of misconduct against him. Now, if your lordship sees further inquiry, that is at annexure
Page 20.
page 20, ma'am.
Annexure B.
Annexure B.
Last
Last but one para.
20.
As per the provisions in section 5.6 of the bylaws of Governance and Accreditation Council. My lords got it, no? Page 20, annexure B.
Yes.
Last but one para.
Yes.
As per the provisions in so and so, it is informed that so and so you are placed under from your position as advisor pending further inquiry. But this does not say that there has to be an inquiry. Not suspension is, they can immediately suspend and then have an inquiry. So it cannot be said, cannot be interpreted to say that you first start the process, appoint an inquiry officer and then suspend. The director has the power to suspend. And then if your lordships were to see the modification also, annexure B1. This has reference to the suspension order issued. That's at page 21.
Yes.
This has reference to the suspension order issued to the competent authority mentioned above. I'm directly inform you that modification to the above order is to be noted that your suspension period will be 3 months initially or till the completion of inquiry, which is ever is earlier. This is for your kind information. So we are saying with regard to the inquiry.
Yes.
So that means it is pending inquiry, and the director has the power. So the inquiry is not going to be held by him. He is not going to be a judge in his own cause. And apart from this, since he himself says about reconciliation.
No, he is saying that now that by suspension, it is effect is right. It has been done by that person who has an vengeance against him. That is
Not
what.
vengeance, no, because
No,
they-
two
there
things
are-
that-
the power of a
No, power, there is no dispute. Then the
They-
law
they-
is
on the merits,
settled,
no,
no, law is settled that pending inquiry, it's enough. It is not that after initiation of the inquiry
Yes,
is
yes,
suspension.
that
That cannot be done at all.
Yes.
Now the thing is that whether this is the allegation which made, is it required for a suspension?
Yes.
See, that's what Supreme Court said. Don't use that word suspension as in a sword. See, if
Now-
consequence of that should be dismissal. If the allegation is that consequence it may amounts to a dismissal, under that circumstances, you keep that employee under outs. And second thing is that if there is any serious allegation of any corruptions and all, if he allowed to continue, he will tamper the records. Here, what is there for tampering?
Well, that I have no.
What that Supreme Court
with-
said.
With regard to that, no quarrel, Melody, that we are.
Think.
Now the question is, it is not vendetta.
No, you, no. that-
Because he
Even the suspension itself is not that he has committed anything. It is that the
No, no.
purpose of suspension is that one should not be allowed to there, he may be tamper the records. Here is the case where nothing is there for him to tamper, because if it is.
That I straight away. Melody, before
But
that, may
other
I
thing
just
is
make,
that,
make-
no, other thing, director has a power, then disciplinary inquiry, pending disciplinary inquiry can be suspended. The thing is
Melody,
that
yeah,
just
ultimately-
because you have a power to suspend, you can't suspend everybody. That's what.
Now what happens is, the powers with regard to misbehavior, my lord, there are certain things which they also use retrograde or unparliamentary words, my lord, which are used.
Conduct inquiry and punish him. Why do you want to keep him away from the work? See, the purpose is you have to pay that subsistence allowances without taking any work.
That was the first thing we are, not when being briefed.
Then the second thing is, he wants to go out. If you don't want him, accept his resignation and send him back.
That's all. Even now I am telling that you
Then it
accept.
shows that
what is
some purpose you have make him to that,
Withholding.
victim.
That VRS, what is that? But may I make one submission?
Yes.
What I am informed is, look, tomorrow the EC meeting is there, and this suspension order is placed before the EC tomorrow itself. So, my lord, there itself, because he's also written a letter that reconciliation. So probably that it could get, I'm not saying what will happen, I'll not speculate. Tomorrow itself, all that I'm saying is, if your lordships, my lord, could have it after.
No, ultimately, what will happen? Censure can be issued in this. He should not be, see, because somewhere what word he has used, that he has admitted that. It is not a case for dismissal.
No,
That
this is not a case for, my lord.
That is what the
dismissal, my lord, cannot
Yeah,
be done. It cannot be done at all.
No, that is what Supreme Court said. In the case, if it is allegation, misconduct, it amounts to a dismissal,
Then
then you
only.
can use
No,
that
but
suspension.
here, suspension, if your lordship sees, I think 5.6, here under these bylaws.
No,
it is
anyhow
very
that-
clearly said suspension shall not be treated as punishment. So suspension
it
itself
is
is
not
not
my
punishment.
case.
No, it is a law. Suspension is not a punishment.
Yes, sir.
But therefore, Supreme Court said, under what circumstances you can be kept under suspension. It is not that employer has a power, therefore I can suspend
Suspend in
everybody.
all
That is not
cases.
the intention. Said that, see, suspension, if he is allowed to continue there, he may tamper that record. If there is a serious allegation about that corruption, he may there, he will tamper. Here, what will be tamper there? See, 2 weeks back, I have decided where that in suspensions matter also, where there is a employee, he will not be allegation which will not be that he is going to tamper any records. Don't keep in the suspension and pay that
Suspension,
public money.
I-
No, anyhow that tomorrow it is there,
Yes,
you
sir.
decide.
So
that.
may I
Milords,
just-
can I just say this, Milords?
request-
Milords,
I'm not-
director coming and
that is
making
the
this
reason,
statement is
that
not
the reason
welcome.
why- That is the reason why, my lord, at the.
What director
outset,
wants to
because
say
we were
this?
served with a copy yesterday evening. At the outset, I didn't come and ask for time, my lord. I allowed my learned friend, my lord, because to submit. Since it is there tomorrow, all that I'm saying is,
I'll-
your lordship may just give us 2 or 3 days time, And my lord, if it
Now,
gets solved, then it is over.
suspension stay ಮಾಡಿ ಅವ್ರು ಎಷ್ಟು ಜನನಾದ್ರು ತಗೊಳ್ಳಿ ಒಂದ್ ನಿಮಿಷ ನಾನು
ಅಲ್ಲ,
ಹೇಳ್ಬಿಡ್ತೀನಿ.
10 ದಿನ ಆಗೋಗಿದೆ
ಈಗ
suspension ಆಗಿ.
ಒಂದ್ ನಿಮಿಷ 10 ದಿನ ಆಗ್ಲಿ 11 ದಿನ ಆಗ್ಲಿ ಈಗ ಈ ಡೈರೆಕ್ಟ್ರು ಕ್ವಶನ್ ಇಸ್ ದಿಸ್.
ಅಲ್ಲ, ಈಗ ಆಗ್ಲೇ 29 ಇಂದ we are in 10. I'm saying it's only another one
No,
day.
no, no, not even an hour. Why should I be kept away from the employment? Not an hour,
Court earlier. Yes, the second
not even an hour.
Day after tomorrow.
29th ಆಗಿದೆ.
Day after
tomorrow, your lordship.
Day after tomorrow, I will.
Lords, may I just persuade this with your lordships? Because director should not have come and made this request to post this matter day after tomorrow. I've got a very serious objection about this.
No, who is that director?
He is the director, he is appearing for the director. Second respondent is the caveator.
Yes, yes.
Lords, I just wanted to say this. They are holding power for the director. Lords, I wanted to say this. Absolutely no difficulty about the proposition that powers of suspension is vested. It can be exercised as per the bylaws. Now, number one, I made a statement. Show cause notice itself is issued without the concurrence of the executive committee. So there is no contemplated inquiry. There is no investigation. Lords, whatever has to be done, the starting point is this fact has to be brought to the notice of the executive committee. If executive committee says, let it be investigated, power comes.
My lord, can
Please
I,
let
as a
me complete
caveator,
it.
Not seek for some time?
No, no.
My lord, as a technicality of.
As a caveator, he should come prepared for the, Lords, as a caveator,
Ravi,
as
now-
a caveator,
now
he
that-
should come prepared with the
now-
court.
Now that is
Lords,
good.
I
Therefore,
don't
am-
want a situation of this nature, my lords.
No,
Lords may
I have-
understand my difficulty. I just explain my difficulty.
See.
Tomorrow, let us assume this happens. I wanted to tell this.
Yes.
Lords, now they are saying tomorrow is the executive committee. Executive committee, whether they want to do it or not is a different matter. Today, I am challenging an order of suspension which has been issued without there being any proceedings of the executive committee in relation to this complaint for any purpose. That's an admitted fact. That's an admitted fact. Because executive committee is sitting tomorrow. Now, they want the matter to be taken up day after tomorrow because they are hopeful that executive committee may say, no, we will ratify this. Should I again come before the court and
No,
say,
no, no. See, ratify is after filing that. That I will consider. Why do
Yes,
I-
my lord, your lordships have already expressed.
See,
They
now
have-
only hopes that they have also a power to revoke it.
Yes.
They may done it.
no, no, ಇಲ್ಲ ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ
Already
ರಿವೋಕೇಶನ್ ನಾನ್ ಕೇಳ್ತಾನೆ ಇಲ್ಲ ಒಂದ್ ನಿಮಿಷ ನಾನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ
29ಕ್ಕೆ ಆಗಿದೆ. They have waited till the 10th.
Day after tomorrow.
Lords,
That's all I'm
I
saying.
wanted to say this. No, this is not a fair submission. The reason, no, I will explain. Lords, if he's short of instructions, let him take instructions.
This, my lord, I don't
No, I
think we
will,
should say whether
Lords,
it's all of it, my lord, this is
I
not-
wanted to say this.
How to make such
Lords,
submissions about
Lords,
the
I
instruction.
wanted to say
Whatever I
this.
said, my lord,
No,
we
I
have to-
want to have this matter day after tomorrow.
Yes,
Lords,
that's all.
We'll see.
Lords,
Day
can
after-
I make this request, my lords? Can I make this request? Lords may keep this suspension order in suspension.
No, what will happen when it is order has been passed?
29.
Lords, after,
29.
Lords, even before 29th, if your lords were to see my
Today,
explanation.
nothing will happen.
Yes, so that's all I'm saying. I don't
Lords,
know why my
even,
direct-
even before this order of suspension is communicated, I had already submitted a medical leave. I was on an approved medical leave on till 3/9. Lords,
But all that we
whatever
consider,
leave,
your lordship has
Lords,
day
I-
after tomorrow.
Lords, I really fail to understand, my lords, why director should do this?
We will have it tomorrow. Yes.
Tomorrow, yes, tomorrow. by the
Lords,
time-
why should the director do all these things against
No, I
me?
am granting time till tomorrow.
Very well, my lords.
Yes. Yes.
Yeah.
Cell number 15.
Lords, at the same stage, my lords, because
Same
sometimes,
step.
yes,
Yes,
grateful, my lords.
yes.
Serial number 80, my lord.
Yes.
Serial number 80. There is a compromise, my lord. Parties are present before the serial number
Serial number
80, my lord.
80.
80.
We'll take that. Yes.
80 is
130
130.
or 230 will come. 230 was the parties to come 230.
These are already ಬಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ.
230 will take that. Even though it is 80, we'll take at 230. Yes.
Serial number 15, Manikanta.
Lord, 15, my lord, what they challenge provisional select list.
Yes.
It is a premature petition.
It's not
Provisional
premature for
selection
the
list.
reason, my lords. Your lordship may
You put
kindly,
an objection to them.
I filed my objections.
Let them consider.
Lords, it has been almost 2 weeks, my lords. They are not considered.
Then you don't worry. Till let them issue a final seniority list.
My lords, if they issue,
Final selection list.
final, my lords, my only submission is this, my lords. Your lordship may kindly see my application at page number 10.
Your Lordship may kindly see the residence certificate number.
Hmm.
And the residence certificate, which I have produced at my Lords at page number 18.
Hmm.
It is the same thing. And my Lords, my marks in PUC as well as SSLC is more than what the candidate has secured in the provisional selection list.
Yes.
I'm just seeking, my Lords, if they are rejecting based on my acknowledgement which has been served upon them on my residence certificate, let them consider it. Let them consider and give an explanation, my Lords.
Is what that provisional list, you have filed an objection, that is their duty to see. If they fail to do, then court can be exercised. We can't direct everything to do this. This is your work. We are not here to supervise, Mr.
Kindly, my Lords, I may be permitted just in hearing on that time, my Lords, when they take the provisional.
In this writ petition, petitioner called in question provisional selection list.
Yes, my Lord.
Provisional select list, annexure C, my lord.
The provisional selection list. Petitioner has also filed an objection to that. Since no final selection list has been issued, the writ petition filed by the petitioner is premature. Accordingly, writ petition is dismissed, reserving liberty to the petitioner to approach this court.
But sought for mandamus also, my prayer number 2.
What is that mandamus?
That is for consideration of my objections, my Lords. And
They have to, if they fail to consider, then he has to.
kindly, my Lords.
Yes. If petitioner is agreed by the final selection list, if any issued by the respondent, he is liberty to approach.
A direction may be given, my Lords, that let them consider it.
They have to consider once.
No, my Lords.
Provisional selection list ಮಾಡದೆ ಅದಕ್ಕೆ.
Kindly, my Lords.
ನಿಮ್ಮ objection ಹಾಕು ಅವ್ರು ನಿಮ್ಮ objection consider ಮಾಡ್ದನೋ ಆರ್ಡರ್ ಮಾಡಬಹುದು. ಅದನ್ನ ನಾವು ಫೈನಲ್ ಅಲ್ಲಿ ಇದ್ದಾಗ will decide.
Adhe, my Lords, if my objection is there, let them consider. That is
They
my
have to,
request.
yes. If they are not considered, then you come with that.
That I would not be known, my Lords, because I will not be party to anything that
They
conspiracy.
will answer if you have taken this contention.
Kindly,
In
my
spite of that, they have issued a final selection list.
Kindly.
Then you can challenge. Then we will ask that to answer why that. The stage will come. when
Kindly,
that-
liberty may be granted.
It is their liberty. Yes.
Kindly, great. my Lords.
Office objection, first time matter, serial number 16, Bhatt Shankar,
Yes, 2 weeks time is granted to comply of
serial number 17, Bhatt Shankar.
same.
Fourth time office objection, serial number 18, Vijay Kumar for petitioner.
Appearing for petitioner, office objections are complied, my lord.
What is
Kindly
that?
list it for preliminary hearing.
No, still 4 objections are there, madam.
Already office objections are
2 weeks
complied.
time is
my lord.
granted to comply of objection. Yes.
Acha.
ಏನಂತ Yes, who is the counsel who is appearing?
For order, serial number 19, land loss, serial number 20, government advocate.
Yes, Mr. Government Advocate. You have taken the file for compliance, then you have not returned.
Lord, sorry,
This
my
was
lord.
that earlier, we are allowed to take that file to office and correction. It has been not given back.
My lord, I will take instruction and I'll make submission. It may be taken tomorrow, day after tomorrow, my lord. Our
Now,
reason
where is
goes
that
to-
19? Yes,
Serial number 19, land loss. Serial number 20.
19, none appear for the appellant. It appears that appellant is not even when that court file has been taken back for complaints of the office objection. The office objection is not complied and file has not returned, and none appear for the appellant. It appears that appellant is not interested in prosecuting this appeal, hence dismissed.
Serial number 20, government
20,
advocate.
yes, you
20, my
verify.
lord, I will make submission. It may be
Yes,
taken
weeks time,
weeks time.
the request of counsel, government advocate.
Serial number 21,
Yes,
land
Mr.
loss.
21, same order. First ಅಲ್ಲಿ ಮಾಡಿದ್ರಲ್ಲ,
ಹಾ, ಸರ್.
2019 ಅಲ್ಲಿ ಮಾಡಿದ್ರಲ್ಲ,
ಹಾ, ಸರ್.
same order.
22, Chandrasekhar P. Patil.
Yes, Mr. Patil.
22 the office itself has lost the file.
No.
ಇಲ್ಲ,
ನಿಮಗೆ ಫೈಲ್ ಕೊಟ್ಟಿದಾರಂತ ಅವ್ರು.
ಆ ತರ ಬರೆದಿದ್ದೆ ತಪ್ಪದು, ನಾನು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀನಿ ನೋಡಿ.
ಎಲ್ಲಿ ಕೊಡಿ.
ಹಾ, ಸರ್.
I have issued with a notice. Then I said that after transfer of
It is transfer from where?
ಅಲ್ಲ ನಾನ್ ಧಾರವಾಡಕ್ಕೆ ಹೋದ್ಮೇಲೆ
ಹಾ.
ನಾನು NOC ಕೊಟ್ಬಿಟ್ಟಿದ್ದೆ ಫೈಲ್ಗೆ.
ಹ್ಮ್.
ಆ NOC ತಗೊಂಡವರು ಏನು ಮಾಡಿಲ್ಲ.
NOC ತಗೊಂಡವ್ರು ಫೈಲ್ ತಗೊಂಡೋಗಿದ್ದಾರೆ.
ಏನ್ ಮಾಡ್ಯಾರೋ ಗೊತ್ತಿಲ್ಲ.
ಮತ್ತೆ ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ. ಅವ್ರ ಫೈಲ್ ಕರೆಕ್ಷನ್ ತಗೊಂಡೋಗಿದ್ರೆ who is that counsel who has taken NOC? ನೀವ್ ಯಾರಿಗೆ
ಆಮೇಲೆ ಗೊತ್ತೇ ಇಲ್ಲ. ನಾನು
ನೀವು ಕೊಟ್ಟಿದ್ರಾ?
ಪಾರ್ಟಿನೇ ತಗೊಂಡೋಗಿದ್ದೆ.
ಹ್ಮ್.
ನಾನೊಂದು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ.
Then I will record your statement saying that party has taken the
ಹೌದು
file.
ಹೌದು ಹೌದು.
Yes, learned counsel for the petitioner appellant submits that he has given no objection to the appellant to engage any other counsel
2007 itself.
in the year 2007. Thereafter, he has no instruction from the parties. And the appellant also has not engaged any counsel. Therefore, it appears that appellant is not interested in prosecuting this appeal. Dismiss.
Serial number 23, Ravi B. Nayak.
ಅದರಲ್ಲಿ ಇದನ್ನ ಹಾಕಬೇಕು. Office note says that file is not received from the complaints from the council. ಆಮೇಲೆ council submits that. ನಾಳೆ ನಮ್ಮ ಮೇಲೆ ಹೇಳ್ತಾರೆ ನೀವು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ ಫೈಲ್ ಇತ್ತು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. Yes, you make the note. Office ಮಾಡಿದ್ರಿ. ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿದ್ದು ನೀವು ಆರ್ಡರ್ ಮಾಡಿದಿರ. Office may say anything. Yes.
Serial number 23, Ravi B. Nayak.
ಅವೆಲ್ಲ ಕೇಸಲ್ಲೂ ಅಷ್ಟೇ. Post it with the office note saying that file has not received. Then council has submitted order. Yes. Serial number
23, Ravi B. Nayak.
Yes, Ravi B. Nayak. Yes, office note says so and so. Even today, when the matter is called, none appear for the appellant. It appears that appellant is not interested in prosecuting that appeal and dismiss for non-prosecution.
Serial number 24, DB Satish.
Yes, same order.
Serial number 25, Ashok Arnaldi Associates.
Yes, same order.
Serial number 26, SR Egde Udlamane.
Yes, same order.
27, KR Nagendra.
Same order.
28, KLM Shabir Ahmad.
Same order.
Serial number 29, Swami NB Lakshmi for petitioner, KM Prakash.
I am for
Yes.
the sixth respondent.
Fourth respondent is the contesting respondent.
Yeah. Who has filed memo for retirement?
Respondent number 4.
No, somebody has said he is filing ವಕಾಲತ್ ಎಲ್ಲೋದ್ರು ಅವ್ರ ಬೆಳಿಗ್ಗೆ.
Adjournment ಕೇಳಿದ್ರು.
ಆಯ್ತು, ಅವ್ರ ಹೆಸರು ಯಾರು ತೋರ್ಸ್ಬೇಕಲ್ಲ ಯಾರು ಅಂತ. ಪ್ರಕಾಶ್ ಅವ್ರು ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿರತ್ರಿ. ಮತ್ತು ಇನ್ಯಾರೋ ಒಬ್ರು ದೇ ಆರ್ ಫೈಲಿಂಗ್ ಏನು ವಕಾಲತ್. Keshav PH. Yes, learned counsel for the respondent has filed a memo for retirement enclosing the acknowledgement having file has been written, acknowledgement wherein that petitioner, respondent number 4 has signed that NOC. The memo is taken on record. Sri KM Prakash, learned counsel for respondent, is permitted to retire from the case. Yes.
Date may be fixed, my lord, because it's question of audit objections.
Yes.
My payment has been held up.
I have filed wakalat for R4.
What is your name?
R8380H.
Yes. And so has filed a wakalat for R4. Office is directed to show his name. Yes, leave this matter on 26th. Yes.
Serial number 13, Nishant AV for petitioner, connected matter, Kevin Narasimhan.
Yes. Yes. First matter, 849. Yes. Filed a memo seeking leave of this court to withdraw. Yes. What about second matter? Who has filed?
I have filed impleading.
ಎಲ್ಲಿದೆ impleading application ತೋರಿಸಿಲ್ಲ. Where is that application?
I am 3.
In the cost list it is not shown.
My senior's name is shown. Shiv Prasad.
ಕೊಡಿ.
Nishant.
Or it is in the respondent side, my lord, impleading application.
ಅದು ಇಲ್ಲಿ ತೋರಿಸ್ಬೇಕು ಏನು. Yes, you have no objection. Yes. ಎಲ್ಲಿದ್ರಿ? Second minute. IA 3 of 24. 3 of 24.
Please, Mullah.
Yes. IA 3 of 24 is filed by the impleading applicants. Yes. Learned counsel for the petitioner has no objection to allow that application for the reason stated in that application. The IA is allowed. The impleading applicants is permitted to come on record as respondent number 7. Counsel for the petitioner is permitted to amend the cast. You amend it? Yes.
Take weeks time to file my statement of objection.
When do you want, when will you file?
Weeks time I'll file my, within weeks time I'll file my objection.
Yes. Yes, 26th. Yes.
Sir, amendment.
Yes, 25th. In the meantime, you have to file objection.
Please, Mullah.
Yes.
Amendment. Amendment. Cell number 31, K.R. Ganesh Rao, office objections.
Yes.
Third office objection.
We'll see. Prior and the interim prior to be specific. What is that prior? ಏನ್ ಈ ತರ ಪ್ರಯರ್ ಇದ್ರೆ ವಾಟ್ ಇಸ್ ದಟ್ ಪ್ರಯರ್ ಮಿಸ್ಟರ್? ಪ್ರಯರ್ 5 ಪೇಜ್ ಐತಲ್ರಿ. ವಾಟ್ ಇಸ್ ದಿಸ್ ಪ್ರಯರ್? ವಾಟ್ ಯು ವಾಂಟ್ ಟು ಸೀಕ್? Order quash the part of the term of the condition stating that absolute agree in para memorandum. No, ಆಯ್ತು first prayer ಆಯ್ತು. What is the second prayer? One page ಇದೆಯಲ್ಲ. No, no, you read one page ಆಯ್ತಲ್ಲ ಏನದು? How this connected? No, issue writ in the nature of certiorari or any other writ order quashing the part of the term and conditions stating that also agree not in initiate and any proceedings. ಎಲ್ಲಿದೆ ಅದು? ಯಾವ್ದನ್ನ ಕ್ವಾಶ್ ಮಾಡಕ್ಕೆ ಹೇಳ್ತಿದ್ರೆ and which it is? ಎಲ್ಲಿ under which? Where is that?
Page number 79.
Para 8 of the memorandum understanding arrived at between that Indian Bank Association and the United Union extra so and so so and so. And in para 14 joint note dated arrived at between that Indian Bank Association. What is that? And para 14.3 of the joint note. Joint note entry adu 8. Then you have to mark. See, in the memorandum of understanding between the bank association, it is marked as so and so, but you have to make that annexure. El madidira. No, prior you have not mentioned that, Mr. Aitri priorly this condition made in that memorandum of understanding produced as annexure so and so, and has to be say. It is not that quashing that memorandum of understanding under ಯಾವುದು ಅನ್ನೋದು ಬೇಕಲ್ಲ. Make it correct, mister. No, in the prior itself, we have to say, mister. No, each prior, no, prior B, you want to strike off that word, also agreed not to initiate any proceeding concerned in the future in annexure, so and so has to be mentioned, mister. Yes. 2 weeks time is granted to comply of subjects.
Cell number 32, Subramania Patyam for petitioner.
Yes, Mr. Office Objection.
The only objection is that, my lord,
Prior of the teacher of 6th respondent schools to be made in the party.
my lord, here, my lord, what has happened is, my lord, these are the petitioners, they are the students, my lord, studying in the 6th respondent school. Now, my lord, they have become desperate on account of the fact that, my lord, one post of Kannada CBZ in the 6th respondent school, my lord, is treated as excess.
The benefit will goes to each student.
No, it will not, because, my lord,
No, it is not a public interest litigation.
my lord, it is not a public interest litigation.
See, you have to pay that court fee for each student. Then file it by one student. Why do you want all students to be made?
My lord, I have stated, my lord, your lordship may be kind enough to see my explanation, my lord, in the writ petition. Please have.
No, see, if it is relief granted, one petitioner is enough to all. Why do you want to make all them? You pay one petitioner, you seek.
My lord, we are not claiming any individual relief. My lord, our attempt is
No, not individual relief. If the relief is goes to benefit to that all, then they have to pay the court fee.
My lord, here we are not going to gain any monetary benefits. My lord, our prayer is.
Not gaining and all. It is not that to gaining the monetary benefit, you are paying the court fee. Court fee is paying to service given by that state.
Lord, my submission is,
Yes,
Lord, here my prayer is, my lord, only against treating the post of the Kannada CBZ teacher as excess in the 6th respondent.
Mister, party who is before the court, he wants to prosecute, he has to pay the court fee. It is 100 rupees. If one person is enough for that, don't make others as in a party.
Lord, then in that event I will pay it. But only my difficulty, my lord, there is a great urgency, my lord, in this matter. Lord, subject to my paying the court fee, my lord.
Pass over, you pay that court fee.
Very well.
Yes.
Serial number 33, Shyam Sundar Bajpekar for petitioner.
My lord, appear for petitioner.
Yes.
My lord, just now I have received the objections from respondent number 1 to 3. My lord, kindly pray for time full.
I have serious objections, my lord. Copy was served yesterday. I'll not rely upon the objections. I'll just make two. Your lordship may kindly see.
Is there any stay here?
Yes, my lord. Your lordship may kindly see the order dated 3rd September, my lord. 3rd September. Last sentence, my lords. In view of the above, the respondents are directed to go on with the interview to be held as per the notification, but not to issue any appointment till the next date. The only case is, my lord, non-compliance of the judgment of this honorable court, my lord, with regarding to amendment of the bylaws and C&R rules.
Yes.
Misleading this court, my lord, saying that we actually amended the bylaws and the C&R rules, pursuant to which we have done and he's an applicant also.
Yes.
He doesn't disclose all this. It's nothing but abuse of process of court, my lord.
Yes, we will permit it to issue appointment order subject to the result.
Please, my lord, please.
Yes.
That's all I'm asking.
Additional Advocate General appearing for, the Advocate General is appearing for the state.
My lord, I am appearing
Submitted
for
that.
R3.
Yes, submitted that. As per the directions of this court in writ petition 26761 of 2024, the state has amended the
Bylaws, my lords. On 27th May 2025.
For compliance of this order, they issued a notification. In view of the above, the interim order granted by this court on 3/9/2025 is modified. The respondent is permitted to issue an appointment order to the selected candidate. The same is subject to the result of the.
Grateful to you.
Yes. No. Interim orders.
Hearing interlocutory application matter, serial number 34, Anusha L for petitioner, Poonam Patil.
My lord, senior is held up in another court. May kindly be passed over, my lord.
Pass over.
Saying that there is a vacancy. As on that date, not 2004, there was no vacancy. Then an objection compulsory ಹಾಕಬೇಕಾಗಿದೆ ಯಾಕಂದ್ರೆ ಸ್ವಲ್ಪ ಮಿಸ್ಚಿಪ್ ಆಗಿದೆ. Objection ನಾನು
When do you want?
Kindly pass over, my lord.
He wants to file objection.
Pass over, madam. Please, my lord.
Government advocate press weeks time to file objection.
Let's in this matter, there's an interim order. I appear for the respondent by 5 college. Interim order was staying annexure C, which is a notification calling for appointment for that post. A petitioner is retired. If not, interim order does not.
See, we'll hear one for all. If one respondent is seeking time, other is say not to extend, then he is ready to that argue. Then interim order.
Pass over, my lord.
Yes.
Please, my lord.
This matter on 22nd. Yes, interim order granted earlier is extended till next date. Government advocate seeks time to file objection as a last chance. This matter on 22nd. Interim order granted earlier is extended till next date.
Case number 35, Satisha DJ for petitioner, TP Muttanna.
But kindly have it on Monday. I'm ready for addressing arguments on merits.
Hmm.
Monday it may be given.
Yes, Mr. Any objection because your application is there. Sorry.
Monday will ready.
Not Monday, 17th.
Please.
Is 17th. At the request of petitioner, use this matter on 17th.
Please.
Case number 36.
Interim order may be extended.
Chandrakant Argole for petitioner, government advocate.
My lord, I appear for the petitioner.
Yes, Mr.
This is a case where, my lord, the petitioner has been working as a commander. He was appointed on 7/9/23. He for a period of 5 years.
Yes.
5 years, my lord, would expire on 7/9/2028.
Yes.
He has still 3 more years to serve. Now, in the meanwhile, my lord, one lady who is no more in service, according to me,
Yes.
she makes a complaint on 12/12/24. I have submitted my statement, my lord, on 19/2/2025. A recommendation was made on 29/5/2025 to the state government by the committee, saying that I am entitled for termination. Therefore, I filed this writ petition. Thereafter, my lord, the government has taken a decision to terminate my services, and that I have sought for stay of that order on the ground, my lord, that there is no inquiry. Now, your lordship kindly see, my lord, your lordships observed, my lord, the other day that your lordships have passed an order regarding filing of an appeal. Appeal, my lord, against the recommendation, my lord, as required under the provisions of this POSCO Act, my lord, POSH Act. I will prefer an appeal.
No,
So
you-
I have got
because-
other submissions to make, my lord.
What is that you are challenging the termination?
At
order?
that termination order, it needs to be stayed for the reason.
You argue on the termination. order.
Yes.
Yes. Which is
Now-
that annexure H?
Annexure H, my lord. No reasons have been assigned, except page 98, my lord.
ಗೌರವ ಸಮವೇಷ್ಟ ಸುದ್ದಿಯನ್ನು ಅಧಿಕಾರ ದುರುಪಯೋಗ
Amended writ petition number 89.
89. Yes, Mr. Without inquiry, you can be terminated.
My lord, we have considered the report of the internal committee, my lord.
That is not
Based
that.
on
That is for initiation. You have to conduct an inquiry. Yes, we'll stay that order. Yes. Learned counsel for the petitioner submits that. Impugn termination order annexure H dated 24/7/2025 is passed without giving any opportunity to the petitioner. In view of the above, stay of annexure H dated 24/7/2025 till next date of A. Yes.
Cell number 37, Subramanya Bhattam for petitioner, M. Veerabhadraya.
Lord, this is totally a frivolous and untenable application, Lord, seeking impleadment. I have filed my objections. Lord, he is not at all a necessary and proper party to this proceeding.
What is your case, Mr.
Lord, my case is that, Lord, I am eligible for promotion to the post of professor. Now, Lord, I am the senior most associate professor. This impleading applicant, Lord, who retired on 31/5/2025 as a professor.
Yes.
31/5/2025.
Yes.
Lord, he retired. On account of his retirement, my lord, one post of professor fell vacant in the Department of Urology. And then, my lord, a DPC was convened. In the DPC, my lord, my name has been considered for promotion with a specific recommendation that I possess all the eligible qualification and I am also fit for promotion. My lord, I have produced that DPC meeting. Please have a look at, my lord, page 23, annexure D.
Yes.
Lord, I will not trouble your lordship by reading the whole thing. Please turn to page 30. ಪದೋನ್ನತಿಗೆ ಶಿಫಾರಸು ಮಾಡಿರುವ ವೈದ್ಯರ ವಿವರ ಈ ಕೆಳಕಂಡಂತಿದೆ. ಹೆಸರು, ಪದನಾಮ ಮತ್ತು ವಿಭಾಗ: ಡಾಕ್ಟರ್ ಸಂಜಯ್ RP, ಸಹ ಪ್ರಾಧ್ಯಾಪಕರು, ಯೂರಾಲಜಿ ವಿಭಾಗ, ಪ್ರಾಧ್ಯಾಪಕರ ಯೂರಾಲಜಿ ವಿಭಾಗ, so and so, so and so. So my name has been recommended. Now, my lord, notwithstanding my recommendation by the DPC,
Yes.
now, my lord, I am not being considered for promotion by issuing a formal order of promotion.
Yes.
Now, at this stage, my lord, this impleading applicant, he has come up with this application, my lord, without any reason. My lord, he is already retired. No doubt, my lord, even though he is retired, now, my lord, he has been continued as a super specialty doctor in terms of a government order. My lord, he is no longer a professor. He does not head the Department of Urology. So therefore, my lord, if my direction is issued,
Who has to say, what is the stage of this promotion?
Now, what has happened is, the government has passed an order for the incumbents who are there. Their term of superannuation is extended from 60 to 65. 65. So he was about to retire. This government order was not there then.
Yes.
Then, my lord, the DPC was done in anticipation of he being, my lord, retired. Now, at that juncture, this government order came. He has been continued. Now, there is no vacancy.
No, now he has continued as an,
He has-
it is not
he has-
re-inducting.
So he has continued.
as a specialist
No
doctor
vacancy
only,
also.
as a specialist doctor only,
No, what was he earlier?
my lord, he was a head of the Department of Urology. Besides that, my lord, he was also the senior most professor. Now, my lord, by virtue of his retirement, my lord, he has demitted the office of professor and HOD of the Department of Urology. But, my lord, by virtue of the government order, he has continued as a specialist doctor. Till 65, he will continue to hold that post
No,
of
he is
specialist
not
doctor.
holding that post of the.
No, he is not a
He holds
professor.
it as a
Where is that? Show me.
Yes, my lord, please have a look at annex page 22, page 22, annexure C,
Yes,
second paragraph, page 22, my lord.
yes.
ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಡಾಕ್ಟರ್ ಕೇಶವಮೂರ್ತಿ ಆರ್ ಇವರು ಪ್ರಸ್ತುತ ಹೊಂದಿದ್ದ ಯೂರಾಲಜಿ ವಿಭಾಗದ ಮುಖ್ಯಸ್ಥರ ಕಾರ್ಯಭಾರವನ್ನು ತಕ್ಷಣದಿಂದ ಮೇಲ್ಕಂಡ ಸರ್ಕಾರದ ಆದೇಶದ ಷರತ್ತುಗಳನ್ವಯ ತೆರವುಗೊಳಿಸಿ ಪ್ರಸ್ತುತ ಡಾಕ್ಟರ್ ನಾಗಭೂಷಣ್ ಎಂ ಪ್ರಾಧ್ಯಾಪಕರು ಯೂರಾಲಜಿ ವಿಭಾಗ ಇವರಿಗೆ ವಹಿಸಿಕೊಡುವಂತೆ ಆದೇಶಿಸಿ ಮುಂದಿನ ಸರ್ಕಾರದ ಆದೇಶದವರೆಗೂ ಮತ್ತು ಈ ಮೇಲ್ಕಂಡ ಸರ್ಕಾರಿ ಆದೇಶದಲ್ಲಿ ಇರುವ ಷರತ್ತುಗಳಂತೆ ಹಾಗೂ ಸಂಸ್ಥೆಯ ಆಡಳಿತ ಮಂಡಳಿಯ ಘಟನೋತ್ತರ ಅನುಮೋದನೆ ನಿರ್ಧಾರದ ಷರತ್ತುಗಳಿಗೊಳಪಟ್ಟು ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ವೈದ್ಯರಾಗಿ ಮುಂದುವರಿಸಲಾಗಿದೆ. So, my lord, he has been continued as a super specialty doctor and not as a professor. So, as on date, the post of professor is, my lord, very much vacant.
No, that ವಿಭಾಗದ ಮುಖ್ಯಸ್ಥರು.
ಹೌದು.
Yes.
That also, my lord, he has demitted. Lord, to substantiate
No, he has
further.
not been continued as an
ಇಲ್ಲ ಅದರಲ್ಲಿ annexure C ನೇ ಮೇಲೆ ಪ್ಯಾರದಲ್ಲಿ annexure C not what is read now.
Yes. Where is that?
Page 23 of my application R2.
Page 23.
The government
Government
order.
order. My application.
Impleading.
Then operative portion is start from by important order.
Yes, page number.
Page number 25. ಸರ್ಕಾರ ಆದೇಶ.
Page.
ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ಅಂತಾನೆ ಓದಬೇಕು, ಅಲ್ಲಿಂದ ಓದಬೇಕು.
Yes.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಅಧೀನ ಕಾರ್ಯಾಧ್ಯಕ್ಷ ನಿರಂತರ 22 ಪಾಯಿಂಟ್ ಕಾಲೇಜುಗಳು ಮತ್ತು ಆಸ್ಪತ್ರೆಗಳಲ್ಲಿ ಪ್ರಸ್ತುತ ಕಾಯಂ ಆಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ವೈದ್ಯರು ವೃತ್ತಿ ವಯಸ್ಸನ್ನು ಈ ಕೆಳಕಂಡ ಷರತ್ತಿನೊಳಗೆ 60 ರಿಂದ 65 ವರ್ಷಗಳಿಗೆ ಹೆಚ್ಚಿಸಿ ಆದೇಶಿಸಿದೆ. That conditions are 60 to 65 ವರ್ಷ, 60 ರಿಂದ 65 ವರ್ಷಗಳಲ್ಲಿ ವೃತ್ತಿ ವಯಸ್ಸು ಹೆಚ್ಚಳ ಮಾಡಲಾದ ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ವೈದ್ಯರುಗಳನ್ನು ಆಡಳಿತಾತ್ಮಕ ಅಥವಾ ಇತರ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕ ಮಾಡುವಂತೆ.
Wait.
60 ರಿಂದ 65 ವಯಸ್ಸು ಹೆಚ್ಚಳ ಮಾಡಲಾದ ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ವೈದ್ಯರುಗಳು ಸಂಬಳ, ಪಿಂಚಣಿ ಮತ್ತು ಇತರ ಆರ್ಥಿಕ ಸೌಲಭ್ಯ ವಿಸ್ತರಿಸುವ ಕುರಿತು ಆರ್ಥಿಕ ಇಲಾಖೆ ಸಹಮತಿ ಪಡೆದು ಪ್ರತ್ಯೇಕ ಆದೇಶ ಹೊರಡಿಸಲಾಗಿದೆ.
65 ವರ್ಷಗಳು
Professor post is not a academically benefited or is not having independent power to report.
The object of that, my lord,
I cannot depromote because of then moreover, what is delaying the meeting for proceeding, it has to be approved by.
No, I just asking, after that your retirement, has they issued any order?
For my
my
retirement,
lord, may I read one more, that the very object of that R2 is issued, my lord, may I read?
They have issued subsequently
Lord,
two orders.
Vishya,
my lord.
Vishya may I read Vishya, my lord? ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಖಾಯಂ ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ವೈದ್ಯರ ನಿವೃತ್ತಿ ವಯಸ್ಸು 60ರಿಂದ 65ಕ್ಕೆ ಹೆಚ್ಚಿಸುವ ಕುರಿತು. ಲಾರ್ಡ್ ಮೇ ರೀಡ್ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಅಲ್ಲಿ ಯಾಕೆ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂತ. ಮೇಲೆ ಓದಲಾದ 1ರ ವೈದ್ಯಕೀಯ ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಅಧೀನದಲ್ಲಿ 22 ಸ್ವಾಯತ್ತ ವೈದ್ಯಕೀಯ ಕಾಲೇಜುಗಳು ಹಾಗೂ 10 ಸೂಪರ್ ಸ್ಪೆಷಾಲಿಟಿ ಆಸ್ಪತ್ರೆಗಳು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು. So and so, because my lord,
See, order is issued on 16/5.
ಹೌದು.
His age of retirement is 31/5. Before that, it has been extended.
Yes, my lord, by virtue of this.
Then he is a necessary party. Will
Lord,
implead it.
I'll come to that, my lord. My lord, after this government order has been issued, subsequently, my lord, 2 more orders have been issued. Can I just place on record, my lord, those 2 orders?
No, that will hear, but
Lord,
he is
these
a
orders,
necessary
my lord,
party.
My submission is, my lord, these orders make it manifestly clear that, my lord, he has not continued as a professor.
Yes.
My lord, my point is only to bring to your lordship's mind.
unless I come on record, I cannot say
Lord-
anything about this document.
My lord, please have a look
No.
at it.
No, by allowing him to come on record, it will not affect your
Lord,
right.
what, my lord, it will certainly hamper my relief, my lord, for this reason. My lord, this DPC has considered my case, my lord, about 3 months back. Now he still claims that, my lord, he has continued as a professor.
See, just because DPC is held, it will not create any right unless there is a vacancy.
Lord-
Now, what you are saying in a vacancy, now he is disputing, that will decide.
Lord,
He is
I'll-
a necessary party.
My lord,
Now,
my
today is for an application. I have satisfied that he is a necessary party. I will allow that. Let me see. Yes. IA, ಎಷ್ಟು serial number? Serial number ಎಷ್ಟು?
Serial number 37, sir.
Yes, IA 1 of 2025 is filed for impleading. Peruse that application. IA 1 of application, the reason stated in that application. In view of the above, the petitioner, the impleading applicant is a necessary and proper party in this writ petition. Hence, IA 1 of 2025 is allowed. Counsel for the, he is permitted to come on record as respondent number,
Respondent number 4.
respondent number 4. 3. Respondent
Three,
number
three.
3. Counsel for the petitioner is permitted to amend the cast title. Yes.
My lord, my only request, my lord, if at all he wants to file objections, let him file it at least, my lord, immediately.
Fix the date, yes.
My lord, so that I can,
How much time you want to file objection? Yes.
Lord, but-
Respondents are granted 2 weeks time to file objection finally. Leave this matter on 25th.
very
Yes.
well.
We'll hear that. That is
Very
the
well.
only point. If you shows that he has not continuing that post still vacant, then only your right will create.
Very well.
Otherwise, there is no right. Yes.
My lord, can I carry out the amendment?
Yes, yes, permitted to carry out. Yes.
Serial number 38, RB Sadashivappa for petitioner, TP Muttanna.
My lord, may I request my lord to kindly have it next week because the copy is served just now. I'll
Yes,
file my
Mr.
objection to that. After all, it is a premature transfer case, my lord.
For current circular, just put 2 permanent messenger. One permanent messenger is retired. Another permanent messenger is posted immediately. Accordingly, that batch has posted one. And it is reported in the market here in that. Now, permanent messenger is not posted. I will take a very, very serious issue because this is current messenger is owned by highway, managed by the bank. All services are in the.
No, he is saying that term is fixed for 2 years.
No, that is normal. He was there 12 years in that one building, regional building. Now he has to transfer 500 meters. And that is not applicable in the administration. Here, there are no other permanent messengers in the region.
Yes, Mr. Counsel.
Now, in other cases, that are within 4 months, that is cannot be done as per the regulations.
Yes, Mr. Sadash.
Yes.
Yes. You are ready. We'll hear that. He is saying that there is an urgency.
ಅಲ್ಲ
And
urgency,
you are not transferring from one place to
ಅಲ್ಲ,
other. It's in the same building.
transfer
See
case.
that administrative exigency also.
ಅದಕ್ಕೆ ಕಾಪಿ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes.
ಅದು ಒಂದು ವಾರ ಟೈಮ್ ಕೇಳ್ತಾರೆ.
Yes.
ಅಲ್ಲ,
Day
ನಾವು
after
objection
tomorrow.
ಹಾಕ್ಬೇಕಲ್ಲ.
Day after tomorrow. Yes.
ಅಲ್ಲ, next week ಹಾಕ್.
Yes, Monday.
Please,
Yes.
oblige.
B group matter, serial number 39, Subramanya Bhatti M for petitioner, connected matter,
My
SK
lord, in
Ravi.
this interim order is there. may
Interim
kindly
order
take-
granted earlier is extended. You want to file objection? How much time you require? No, you want to file objection? File. Yes. Will he? All are filed an objection. What is that non-compliance, Mr.?
That is
Objection.
only production of original of the document. I'm just looking to-
File an application for
I will
dispensation.
do that.
Yes. Week's time is granted to comply that office objection. Let us, yes.
Serial number 40, Rajaram T for petitioner, PC Prabhakar.
Has asked one pertinent question regarding how we are entitled for this benefits and all. In this regard, I filed an office, the memo along with the documents, my lord, recently we filed it on 4th September 25, my lord. My lord, wherein, my lord, it clearly says, first, my lord, there is an advertisement which was issued with,
You just give that brief facts.
my lord, you brief facts, Mr.
My lord.
Say, in this case,
Yes.
my lord, the petitioner was appointed, say,
Who is your opponent?
opponent, my lord, BC Prabhakar.
My lord,
Ready, Mr. Prabhakar?
my lord, my colleague who is in charge of this case, my lord, he has gone to Bombay, my lord. He will be back tomorrow. I request for short accommodation, my lord.
Yes, at the request of counsel for respondent.
Very short date, my lord.
Yes, leave this matter on 25th.
25th.
Yes.
Initial patra haki parvai.
24th. Yes.
Yes, ma'am.
24th.
Much blessed.
Serial number 41, Srinivasa K for petitioner, NK Ramesh.
Yes. 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 Yes.
Now, in the meanwhile, they claim to be these nurses. They want the dispute to be fixed on par with government employees. I spoke to the management in the morning, my lord. They want me to request for one more week.
You are under consideration.
We will consider that, my lord, I have filed my statement of objections, my lord, I will argue. But in the morning, my lord, I have received a phone call saying that.
Yes, if they are positively considering, then you wait for that.
I have no objection, my lord. The matter is pending for the last 6 years. So far, they have not taken any steps. On the other hand, my lord.
There is any, this thing, they may thought that instead of court directions, they might have been considered. When do you want?
Next week, any date, my lord.
Yes, 18th.
Please.
Yes.
Problem.
At the request of respondent, leave this matter. File it in that counter, madam. Yes.
Serial number 42, Janardana G, B Vinayaka for petitioner,
My lord, appearing for petitioner.
appointed advocate.
My lord, in the last occasion, your lordship are directed to file a chart on record, my lord. Short accommodation to file regarding.
Lord, matter was substantially heard. The, my lord, it was relating to their entitlement to be placed in the 4th stage of AGP.
Where is it?
They
Where
had
is
to present a list of dates
Short accommodation
to
will
say
be given, my lord. We'll place it.
on what
with
dates they
memo, my
moved
lord.
from one
Now
grade to another.
Yes, at the request of counsel for the petitioner, is this matter of 2 weeks. Yes.
43,
My lord, date may fix.
Shivakumar U.
Date.
Yes, after 2 weeks, let us see. Yes.
Please.
43, Shivakumar U for petitioner, Vikram Unni Rajagopal.
What is that, Mr. What is this, Mr. Matter, Mr.? None appear for the petitioner. Leave this matter after 2 weeks.
Serial number 44 adjourn. Serial number 45 Sagar BB for petitioner. Swati Panduranga.
Yes, Mr.
But I appear for the petitioner. That's the matter minutes pertains to regularization.
Yes.
That's the petitioners before your lordship's minutes are working minutes as medical officers minutes, Ayush doctors. Notes all of the petitioner minutes have put in 20 years of service minutes as on today. Notes they made minutes a claim for regularization. That representation minutes was not considered. They came before this honorable court minutes. A direction was issued. Minutes for consideration of the representation. Now minutes the representation minutes for regularization is rejected. Minutes primarily on the ground minutes that the appointments as against the post minutes were non-sanctioned post minutes and as such minutes.
Where is that endorsement?
Minutes endorsement minutes is at page number 161, annexure K.
Yes.
Lordship, in this case, learned AAG Rubin Jacob appearing. So far as the regularization matter is concerned, Your Lordship, date was given on 22nd, Your Lordship.
ಎಲ್ಲ ಎಲ್ಲಿ here ಮಾಡಕ್ಕಾಗತ್ರಿ 22nd ಪೂರ್ತಿ matter. Whether you are the contesting or they are the contesting.
State minutes is the contesting. They minutes have sponsored a
If they
scheme.
want to commence, my lord, we'll argue. If they want to commence it, we'll.
No, if it is at a stretch, if you are ready, we will hear that.
We'll
Or
argue, my
we
lord,
will
if
have
they
it
want
on
to present.
22nd.
Argue
We'll
now.
see. 22nd.
22nd.
Yes.
That's interim order may kindly be extended.
Request of government advocate, leave this matter on 22nd. All will go after this thing, Mr. You can't hear on 22nd all this matter. Yes.
That's the interim order may kindly.
Interim order granted earlier is extended till next date of hearing.
Obliged.
Serial number
But
46.
taking that service of 20 years, after that, asking
Now the
to go out,
concept of
they are
minutes,
all
non-sanctioned post minutes is
depending
diluted.
on
We will give clarity, my lord, on that aspect. My lord, our
No, that's-
difficulty.
You can be say on that law. See, Supreme Court said you are in a constitutional employer.
Is-
You are exploiting that citizen. See, 20 years they are married, they are depending upon their family. Then you are saying that you are not regularizing.
My lord,
Where they
this
will-
question is answered, my lord, in para 5 in Umadevi's case.
Yes.
Whether it
No,
is
Umadevi's
equity
case,
only
my
for
lord,
the
is
few
now
people who are
substantially
before the
minutes
court,
diluted.
or equity for the people, millions of people who.
There is some
My lord,
promise they
my
have.
lord, there is a protection now, my lord. Under the 2012 Act, Daily Wage Welfare Employees Act, also there is a
No,
protection.
for
They
this-
get security of tenure
for
and
the-
equivalent pay, my lord, which is also confirmed by the apex court in Jagjit Singh's case.
No, that's true, but even in the, under that also you are not considered.
We will consider them, my lord. If they are eligible, there is no, my lord, it is not,
No, we will see.
it is
under
not
that.
for me to say. My lord, there
If
is a limitation for
ultimately-
application of the 12 Act.
Not under that, this thing, whether if they are under that, at least.
I'll make out a
Indeed, my lord. My lord, the division bench of this honorable court, in that GVP case, when it overruled the decision of the learned single judge, made sure that they will get the minimum, the equivalent pay.
Yes, that's will see, yes.
Because it has already been held in Jagjit Singh that even contractual employees are entitled to get equivalent pay of a regular employee in a government service.
22nd.
Yes.
Serial number 46 Abubakar Shafiq for petitioner.
Serial
Rajasekaya.
number 46 appear for the petitioner, my lord. It is with regard to the arrears, my lord. In this case, already this honorable court passed an order at annexure G, my lord. The lordship may kindly see at annexure G, page number 42, my lord. Page number 42, annexure G.
Yes.
Para number 2, my lord. The petitioner is before this honorable court praying for a writ of mandamus directing the respondent numbers 3 to consider the representation dated so and so wide annexure F. It is stated that the petitioner is working as a messenger in third respondent's company. Petitioner has prayed for grant of certain benefits arrears, which according to him he is entitled. Respondent number 2, Housing Finance does not dispute with regard to receipt of representation as per annexure F. Under annexure F, dated so and so, petitioner has requested for grant of certain arrears, which according to him he is entitled to. Respondent number 2 and 3 are legally bound to consider the said representation and pass appropriate orders in accordance with the law. Hence, respondent number 2 and 3 are directed to consider annexure F representation dated so and so appropriate decision with regard to claim petition so and so, my lord. Anantara, my lord, after this order, their legal advisors, that is the present advocates, my lord, they advise, they have given opinion to the respondent number 2 and 3 to settle the issue. That is annexure H, my lord. Your lordship may kindly see annexure H. Annexure H.
Yes.
Annexure H, para number 2. This is the legal advice given by their legal advisors, the present advocates. In view of the above order, I am of the opinion that respondent number 2 and 3 shall consider the several claims made by Sri Shankar J in his letter dated so and so, and if he is eligible entitled for the claims, the same may be allowed, or if he is not entitled for the claims, the same may be rejected with a written reply. The entire process should be completed. This is the legal advice given by the present advocates. And for that, an untenable reply, that is here questionable, my lord. That is question that to quash. Annexure J, my lord. Your lordship may kindly see their answer. Annexure J.
Yes.
The lease accommodation rent from September 2016 to 2018. You had applied for lease accommodation through an application dated so and so, and it was approved by the competent authority, so dated so and so. Later, you have not attended the office, not complied with the requirements, and due to unauthorized absence of the benefits of the lease. This is not actually, my lord, I was prevented from attending the office, not unauthorized. Anyway, my lord, I'll read it out. However, since you have subsequently complied with the requirements, we will now take up for reimbursement at the eligible rates for the period so and so so and so, after deducting HRA paid to you during the said period, and on receipt of proper proof from landlord for the payment of rents made by you to landlord, you have been transferred and reported to at Mysore office so and so. Hence, lease accommodation rent does not fall due from the remaining period of your so and so. Next, Lord, 2. Entitlement expenses from March so and so so and so. Entertainment expenses is a reimbursable expense, and the employee need to apply in EHRMS for getting the payment. Since you had not claimed the above in EHRMS, the same remained unpaid at that time. However, as a very special case, the same will be paid to you. So and so is to. Nantra, salary from January 2018 to 2018. Since you are on UOL from so and so, salary had not accrued, hence not paid. You have been paid salary of May 18 and July 18. Now, my lord, after that, I replied, my lord, for that, that is for consideration here in my lord, that is annexure K, my lord. Annexure K, your lordship may kindly see at page number 49.
Yes.
49. With the reference
No,
to
after
the,
that, no, what has happened after your reply?
After that, nothing happened. They have not paid me. It's still pending. And last time, before last time, their advocate said we will settle the matter. After that settling, nothing happened.
What has happened?
He had failed to come to the office for a continuous span of months, my lord. And because of that, and he had not provided any explanation as to why he didn't come, my lord. Even in the annexures that have been, yes, my lord.
Now, pursuant to that annexure J, he has given some clarification. You
Yes,
consider
clarification.
that
Yes, my lord.
J, for annexure J, he has given a clarification that why I have not attended.
May I read it? May I read that, my lord, annexure K? May I read?
You consider that if it is satisfied, you reconsider that order.
Yes, my lord. In that, my lord.
Annexure K is there.
Yes, my lord.
Annexure K.
Yes.
May I read
My
it,
lord, in the breakdown, my lord, annexure F filed by the petitioner, my lord, page number 38, annexure F. It is the breakdown of the amount that the petitioner is seeking from the respondent number 2, my lord. Annexure F.
Last occasion, the same advocate has said we will settle the matter.
My lord,
Now
first of all,
for the settlement.
yes, my lord. We thought because this is the 2018 matter from Mysore only, my lord. The Bangalore is the regional office, my lord. We had thought that this was a genuine case where the employee had pending arrears from the company, my lord. But on further scrutiny only, my lord, we had understood that this is not a normal case. This is a case where the employee had failed to come to the office citing irrelevant reasons, my lord. And even in the annexure that has been filed by the petitioner, my lord, they have filed a medical certificate where the petitioner was granted a medical leave of 8 days, my lord. And they are using that as evidence to prove that the petitioner was medically ill, and that is why he could not attend the office, my lord. They have not provided any other certificate which states that for
May I
months
read
that
the-
the
may I
petitioner
reply,
was
Lord?
sick, my lord.
How many months he has not attended?
My lord, he has not attended from January 2018 to July 2018, my lord. That is why the month of from January 2018 to July
I
2018, he
he
was
was
not paid his
prevented.
salary.
He
My
was
lord, if I may,
prevented
lord.
to-
No, Mr. Wait. See, you see that annexure J. Approved by the competent authority, you have not attended the office, not complied. See, you have applied for the lease accommodation through an application. The lease accommodation through application dated so and so, it was approved by that. What is that lease accommodation, mister?
Yes, my lord. Lease accommodation is where the petitioner is taking a house on a lease, and the company will pay directly to the owner the lease amount. The petitioner is not involved in it. It is a direct agreement between the company
No.
as well as the
What
lease.
is the meaning of your letter annexure J, first paragraph?
You apply for competent
Through the application?
not compliant with the requirements. Yes, my lord.
You have
Not complied with
attended
the
office, Not
requirements.
complied with that requirement.
Requirement. Yes, my lord. When a lease accommodation is given, my lord, there is a lease deed that should be provided by the petitioner to the company, my lord. It is proof to the company that the petitioner has actually taken a house on lease, and he is liable to be paid the lease amount, my lord. The company will directly pay the owner the lease amount. But
I'm
in this
asking
case,
that-
my lord, he has not provided the lease deed. Despite reminders, he has failed to provide this lease deed, and he is just claiming an amount that I have this much amount as lease deed.
No, he has not, even today, he has not submitted.
No,
this.
he has not submitted the same, my lord. That is
Yes,
why we
Mr.
are also saying that he has not provided the requisite.
For everything, Lord, I have given reply, my Lord. Your Lordship may kindly see annexure K. I may permitted to read it, Lord.
Yes.
Annexure K at page number 49.
Yes.
With reference to the, may I read it, my Lord?
Yes.
With reference to the above mentioned letter, responding the direction of the High Court, Honorable High Court in WP number so and so, and bringing your notice a detailed account which are arrears, and I am entitled for that which you have absolutely not settled. On the contrary, you sent a letter responding to the direction given in writ petition number so and so, which is highly illegal. I am placing here before you following.
First, one in the Odri.
Your allegations that I had not attended the office and unauthorized absence is false. Actually, I applied for sick leave on 7/12/2016 from 5/12/2016 and 2/3/2007 for 176 days, and it was approved. On these days, I was serious from multiple problems like cardiac, diabetic, arthritis, and many other ailments for which I was hospitalized, and there was absolutely no unauthorized absence. My sick leave of 176 days was duly approved by the company area manager. Thus, your allegations of unauthorized absence is baseless, false, and only with an intention to harass me by withholding my arrears. Hence, I am entitled for the amount I have claimed, and you are liable to pay, or else I am constrained to bring the same to the Honorable High Court. That with regard to
Wait, Mr. 170 days leave have been approved.
My lord, that is again, my lord, he is stating in the year of 2016 and 2017, my lord. But in the letter that we have given also, and the salary that he is seeking, my lord, it is in the year of 2018, my lord. Even in his breakdown, as well as the letter in page number 46, my lord.
No, see.
March 2017 to October 2018.
7/12/2016 and 2/3/2017. 165 days you have paid
My lord, that is what he is saying, that his sick leave was approved, my lord. He has not furnished any proof of that, saying that.
No, what is your case that whether you have approved or not?
My lord, that we need to seek further, but this is not the, this has no connection with the matter, my lord. He is saying it's 2016 and 2017. We are not seeking that, my lord.
No,
We are
Mr.
seeking
Counsel,
2018.
you have, in your letter, you have said that on 16/11/2016. Later, you have not attended the office. He said that during that period, I have an approved leave.
No, my lord, in our letter, page number 46, my lord, we are saying from March 2017 to
So
October.
what is that first paragraph, mister?
Competent authority.
Later, you have not attended the office on 16/11/2016. That's the period he has mentioned that I am on leave.
My lord, that is different, my lord. That is not the question.
No, you answer me that.
Yes, my lord.
Whether during that period, whether leave is granted or not.
My lord, I will have to seek further clarification.
Then
That is
what is that you have-
2016 matter, my lord.
Yes, at the request of learned counsel for the respondent. Leave this matter of 2 weeks. Yes,
No, date may be given, madam. Illadre barude illa.
yes, leave this matter on 8th October. Yes.
Much obliged, my lord.
Obliged.
Cell number 47, Shilpa Rani for petitioner, SM Paritosh,
Kindly pass on my license.
What
is the advocate and record will come and argue.
47, sir.
47. Password, you are appearing for?
For the petition.
My lords, I am for respond number 2.
Password.
Same office.
My lords, I am seeking for 1 week, my lords, for
You want
filing
time?
objection.
47,
He wants time, mister.
1 week, my lords. I am for respond number 2, 1 week time maybe.
Grace Gaurav Piraktar.
Yes, he wants weeks time, mister. Learned
No,
counsel
my
for
lordship,
the
we
respondent.
argue the matter, kindly pass over my lordship, that We filed advocate and record objection is- file, my lord, 1
You
week.
have not filed.
No, my lords.
At the request of respondent number 2, leave this matter next week.
My lord, may I submit, my lord, every date, my lord, or my learned friend is seeking the adjournment, my lord. May I submit, my lord? This is the, my lord, the petitioner is aged in 59 years, my lord. This is the 1 year is left. 2011 recruitment, my lord. The matter has been heard, my lord, last hearing data, and
1 week,
directed to respondent number 2 to file the C&R rules, my lord. Now, they have not filed, my lord. I have filed the C&R rules, my lord, along with memo, my lord.
Placed.
Is about to dictate the orders, my lord. That time is they submitted, my lord. It's not a C&R rules followed by.
Last occasion, who has taken time?
The matter is not reached, my lord, last section.
Respondent
Pass over
directed last last occasion the matter not reached, my lord. Before last occasion directed to
22/8,
respond number 2 to
2025.
file. Please, my lord, directed to file the
Objection.
C&R rules, my lord. Now C&R rules has been filed, my lord, along with a memo of documents.
Yes, mister, what is this one? Yes, you have taken sufficient time. It is 2022 matter.
1 week, my lord.
No, why you have not filed objection, mister? You are the contesting.
Please, my lords.
Then
We are sent.
we'll ask your secretary to appear before the court, mister. If you are not filed. Yes.
Next time,
Huh?
we'll file on 1 week. my lord.
What is your name?
Padmanabh.
You are the counsel.
ತಗೋಬಹುದು ಇವರು ಬೇರೆ ಯಾರೋ ಇವರು ಅವ್ರಿಗೆ ಅಪೇರ್ ಆಗ್ತಾರೆ ಅನ್ಸುತ್ತೆ ಇನ್ನೊಬ್ರು ಯಾರೋ
Record counsel, ಬೇರೆ
Not on record counsel is that
ಯಾರು
Mr. SM Paritosh ಇದ್ದಾರೆ
ನೀವು ಯಾರು ಅವ್ರ ಕಲೀಗ?
colleague.
Yes, finally, mister. Otherwise, I will impose the cost. Yes.
My lord, may I submit, my lord? I am the 59 years old, my lord. Only 1 year. If now they give
Request of the
appointment,
learned
my
counsel
lord.
for respondent R2
only
for
one.
file. Yes. Yes,
Short date may
finally.
be fixed, my
Please file
lord.
objection. Yes.
Short date may be fixed,
Yes,
my
yes.
lord.
You have given date.
Yes. Short date, my lord.
24th, yes.
Only
cell number 48,
Yes.
cell number 48, Abhinay YT for petitioner, Sarvana, yes.
Not appear for respond number 1.
Yes. Where is that Abhinay?
Abhinay, he was present in the morning, my lords.
What is this matter?
Not the second respondent, my lord, he passes a order in favor of the percent reservation in promotion, because this is covered under Personal Disabilities Act.
Yes.
Ali, they didn't take any contention that this second respondent didn't have any jurisdiction. Now in the petition, they are taking a stand that the second respondent didn't have jurisdiction to pass the order. It's covered by judgments, my lords. My friend is there, my lord. I would
That
pass.
law itself provided for 3.
Yes.
It need not be any direction.
ಅವ್ರು ಹೇಳೋದು ಇವರಿಗೆ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಪವರ್ಸ್ ಇಲ್ಲ ಪಾಸ್ ಮಾಡೋದಕ್ಕೆ.
Your Lordship could pass order. I am not against somebody getting person, that too the disability person getting an order.
Yes.
But the fact is this, my lord, the Southwestern Railways, the litigation of the railways is taken over by Union of India now.
Yes.
In what capacity
Oh,
my
okay.
learned friend could appear is first
Right.
question. The second question is this, my lord, and I appear for the second respondent also.
Yes.
So therefore, my lord, your lordship may grant me some time. I don't have the copy of the petition also.
Both under central government.
No, now that see what he said, some of the files has taken back by that
Please,
your
Mala,
central
please.
government, and some they have been allowed him to. I think this may be taken. Oh, therefore he is not there. What
No,
is
my
that
lord,
his instruction, Mr.
I just
ನಾನು ಈ ಟೋಲ್ಡ್ my lords will
You will argue.
ಆಫ್ಟರ್ನೂನ್ ಇರೋದಲ್ಲ ಬೆಳಗ್ಗೆ ರೀಚ್ ಆದ್ರೆ ನಾನು ಮಾಡ್ತೀನಿ ಅಂತ
then
ಹೇಳಿದ್ರು.
otherwise let him argue, my lord. If my learned friend if it is not taken, let him argue. That is the first point. Insofar as the other point is concerned, my lord, insofar as the prayer is there, my lord, I have just gone through the prayer also.
Yes.
If he is entitled, my lord, and if the second respondent does not have the jurisdiction, your lordship could pass the order, my lord.
Yes.
Lordship may fix a
Pleased
date,
to
my
issue.
lord.
Yes.
And my
None
name
appear.
may be deleted, my lord. Both of us name has been entered.
Yes. Serial number.
Sir, 48, sir.
48.
Yes. Office is directed to delete the name of KS Bhimaya for R2. Please this matter. None appear for that petitioner. Please this matter on 19th. Yes.
Great. Serial number 49, Rajeshwara PN for petitioner.
Yes.
I appear for the
Saravani.
Yes.
third
It's a matter
respondent,
where
my
my
lords, I have
lords,
received the wakalat today. I will file it, my lords, and at week's time may
They
be
want to
granted, my lords, to
frustrate
file
my,
objections in the
they
matter.
want to frustrate my writ petition, my lords.
No, that.
By saying,
See,
Alla, wakalat
Counsel change.
so bandide.
Pending
I
petition
will file it and I'll file objections immediately.
will grant. That is not the ground to grant.
Even the
No, you
amended
cannot
petition is
change,
not sent.
party cannot, see, after hearing some time, then party will change that advocate. Is it that?
No, no,
you
no.
have to-
First time.
No, somebody is appearing for R3 earlier, mister. Now they are given NOC to
R3
you.
ಅವರು advocate change ಮಾಡಿದ್ರು. R2 ನು advocates change
R3
ಮಾಡಿದ್ರು.
ವಿಜಯ್ ಕುಮಾರ್
This
ನೀವೇ
this is going on, my lords.
No, no, no.
R3
ನಾನು R3
ಇಲ್ಲ,
ಗೆ
ಶ್ರೇವಣ್ ಯಾರೋ
That's it's like this, my lords. Post was invited for appointment of assistant professor. My lords, category, it was the third respondent applied under category 3A, claiming income less than 8 lakhs, my lords. For category 3A, the age limit is 48 years. For general merit, the age limit is 45 years. I also applied under general merit, not under category 3A. He scored 11.58 points in the interview, my lords. I scored 11.33, my lords. Now, my lords, when the preliminary note in the preliminary provisional list, my lords, he was selected under category 3A. I filed objection saying that his income is more than 8 lakhs because he's employed in Dr. B.R. Ambedkar Medical College. He's earning a salary of more than 80 lakhs, 80,000 per month. They said we'll consider it after the final list is published. In the final list published, they publish him and show him as GM category, though his age is more than 45 years.
Not one request.
He is
Lord.
neither entitled for JM nor in that.
Category 3A,
Yes, who has that authority who has issued?
second respondent.
Who is appearing for second respondent?
ಅಟಲ್ ಬಿಹಾರಿ ವಾಜಪೇಯಿ ಇವರ ನಾಗಶ್ರೀ ಮೇಡಮ್ ಅಪೇರ್ ಆಗ್ತಾರೆ.
ನಾಗಶ್ರೀ ಮೇಡಮ್ ಅಪೇರ್ ಆದ್ರು ಅವ್ರ objection ಹಾಕಿದ್ದಾರೆ.
ಹಾ.
They have filed objection saying that on merits we have considered because petitioner score is 11.33.
ಆಯ್ತು, ಮೆರಿಟ್ ಅಲ್ಲ, ಎಲಿಜಿಬಿಲಿಟಿ ಬೇಕಲ್ಲ ಫಸ್ಟ್.
Not before that may I make one submission.
We will file our objections, my lords, because ಅಲ್ಲಿ third respondent ಯಾರೋ ಬೇರೆಯವ್ರು
ವಕಾಲತ್ತು ಹಾಕಿಲ್ಲ.
ಬೇರೆ ಹೆಸರು ತೋರಿಸಿ
Notice ತಗೊಂಡಿದ್ದಾರೆ.
Notice
Notice ತಗೊಂಡಿದ್ದಾರೆ.
I have
They're on
received the
caveat,
copy.
my lords.
P. Srinivas, government advocate, there shall be respondent number 2 order, office verify requesting furnishing further. Insofar respondent learned counsel for the petitioner is permitted to survey copies on the petition paper to 1C, so and so ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಆಗಿದೆ.
ಆ ಶ್ರೇವಣಿ ಅಂತ ಯಾರೋ ಇದಾಗಿದೆ,
ಅವ್ರು
but ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
Caveat ಹಾಕಿದ್ದಕ್ಕೆ ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿ ಅಂತ
ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಅವರು.
ಇಲ್ಲ, ಕೇವೇಟ್ ಹಾಕಿರ್ಲಿಲ್ಲ.
third respondent correct
Counsel,
ಮಾಡಕ್ಕೆ.
Even they did not file ವಕಾಲತ್ also.
Petitioner is permitted to survey copy of the petition paper. ಕೇವೇಟ್ ಏನೋ ಆಗ್ತಂಗಿಲ್ಲ. I don't know whether they
ಅವ್ರು
come
ಬಂದು
before
notice
on that day and
ತಗೊಂಡಿರ್ಬೇಕು.
seek It has
I
passed an
don't
order.
mind my learned friend taking one time, my lords.
ನನಗೆ I will file my objections. in
No,
one
what
week.
is that, this thing, mister? Can
Not
it
one
be-
more, they have filed amended petition, my lord, that is not served because
What is that
when I
amendment?
see the writ petition, he has challenged only provisional seniority list, select list.
Now final selection list has been issued.
ಹೌದು, ಅದಕ್ಕೆ amendment application ಹಾಕಿದ್ದಾರೆ.
Correct. Now, can it be done that if he is not eligible?
Lord, that ಅದು ನೋಡ್
Kodi ಅವ್ರಿಗೆ ಒಂದು copy kodi government.
this.
Yes. How can you be say, now what is, which is the post?
I will
Assistant
go to
professor.
Now he is working.
He is working. During the pendency of the petition, appointment order is issued, my lords.
Yes. When do you want, mister?
I'll file wakala today itself. Maybe called on
Which date? That is the only a point.
22nd or
Huh? Yes, 23rd. 23rd.
It undertakes to file wakalat.
Yes, learned council. ಹಾಕಿದ್ದಾರೆ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿದಾರಲ್ಲ.
ಹೆಸರು
ತೋರಿಸಿದ್ದಾರೆ, ಹೆಸರು
ವಿಜಯ್ ಕುಮಾರ್
ತೋರಿಸಿದ್ದಾರೆ,
R3 ಅಂತ ಹಾಕಿ
ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ. ಹೌದು.
Yes. Learned council appearing for respondent number 3, praise week's time to file an objection. Finally, week's time is granted. Use this matter on 23rd. Yes.
Number 50, Kalyanar for petitioner, H.V. Devaraju.
But in this
That,
case, my lord, the petitioner is seeking for
Needs some time.
non-consideration of his case for career advancement increment. He has attained the age of superannuation. He was entitled as per the circular at Annexure E, he was entitled for
What is that annexure A endorsement?
endorsement. Now, my lord, my request for career advancement increment has been rejected.
On what ground?
Lord, they say that I am not entitled. My lord, first increment is not given. Second and third increment are given, career advancement on completion of 30 and 25 and 30 years. But that should have been considered with retrospective effect from the year 2003, as per the circular of the board.
Yes, first increment is available from which year?
My lord, first increment would be available, my lord, as per annexure E, my lord, as per the circular dated 2012-2002. Page 32, my lord.
32, yes.
If as per this circular, if I have continued in the same post for a continuous period of 20 years, I am entitled for an increment.
ಎಲ್ಲಿದೆ circular?
My lord, page 32. Order ಆದ್ಮೇಲೆ. Corporation is pleased to order that an employee other than those specified in para 6(2) holding a post in any of the first 11 state scales of pay specified below who has continued or who continues in same post for a period of 20 years without a single promotion in the entire service shall be granted additional increment in the scale of pay of the post held by him or next higher scale of pay as the case may be.
When did you appointed as?
My lord, I was initially appointed in the year 1969. 66 was initial appointment on contract basis.
69 is that regular.
There, it's
69,
69 I was regularized, absorbed.
69, 79, 89 ಗೆ ಒಂದು increment ಬರುತ್ತೆ.
ಹೌದು.
ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. And 2000, and as per my lord, the other circular, they are supposed to give two increments. That is annexure.
Yes, Mr. Yes, Mr. Why is not entitled?
I secure the records, but where that it is in the endorsement observed that not in 1997 given promotion and subsequently which has circular has been considered and which is been enclosed ಅಂತ ಬರ್ದಿದ್ದಾರೆ. That which has not been so far as produced. I will get that so far as that is concerned. What was the benefits which has given, which was that enclosed along with this? That is not forthcoming here. That so far as that is concerned. But records today,
you should know
records received today. I'll go through that. If it is there, I'll get the instruction. Kindly thank
No,
you.
that why after 3 years, 2 years after filing, now you are receiving records, now filing an objection. What are you doing for 3 years, mister? Then how will you dispose of that old matter? If this is the
Next week, any date, not that I will.
By the time you are taking and all, my roster will change, then other roster, then they will start taking the time. Whoever may be that, if you are respondent, you have to take an instruction, file an objection. Wherever it matters is reached or court is ready, you have to ready to argue. Otherwise, my order sheet only shows that adjourn, take time, filing objection. Yes. At the request of counsel for That too, when we are free, we are ready to hear and assist dispose of. Sometime ನಮಗೆ ಚಿಕ್ಕಾಬಟ್ಟೆ ಪ್ರೆಸರ್ ಇರ್ತದೆ, ಮತ್ತೆ ನೀವೆಲ್ಲ ರೆಡಿ ಇರ್ತೀರ, ಅವತ್ತು ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕೆ. Yes.
Your date may tell you.
25th. Yes. Right.
Cell number 51, Nagaraj for.
Lordship, I appear for the respondent, Lordship.
Yes.
I appear on behalf of the last date of occasion. I had taken a time to make a submission with respect to the scheme, Lordship. I had made a submission that the scheme has expired.
Yes.
Lordship, I have received the instructions, Lordship. Lordship, the petitioner was appointed under Rajiv Awas Yojana.
Wait, madam, let him hear. Let me recollect that facts. Yes.
But there are two petitioners. The first petitioner is a BE graduate in civil engineering.
Yes.
Second petitioner, my lord, it is doctorate in philosophy. Both are, my lord, 44 years and 53 years as a date of filing the petition.
Yes.
They were appointed, my lord, as per Annexure A1 by the deputy commissioner on a project. Kindly, my lord, read this Annexure A, page 80. Rajiv page Annexure 80. Annexure page 80.
Yes.
ರಾಜೀವ್ ಆವಾಸ್ ಯೋಜನೆಯ ಅನುಷ್ಠಾನಕ್ಕಾಗಿ ತುಮಕೂರು ನಗರಸಭೆಯ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಸೂಚಿಸಲಾದ ನಗರ ತಾಂತ್ರಿಕ ಕೋಶಕ್ಕೆ ಅಗತ್ಯ ಸಿಬ್ಬಂದಿಗಳ ನೇಮಕಾತಿಗೆ ದಿನಾಂಕ 1/8/2013 ರಂದು ಅಧಿಸೂಚನೆ ಹೊರಡಿಸಲಾಗಿತ್ತು. ನೋಟಿಫೈಡ್. ನಂತರ ಅರ್ಹ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಪಟ್ಟಿ ಮಾಡಿ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಅಂಕಗಳನ್ನು ಹಾಗೂ ಅನುಭವದ ಆಧಾರದ ಮೇಲೆ ದಿನಾಂಕ 10/10/2013 ರಂದು 1:4ರಂತೆ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಸಂದರ್ಶನಕ್ಕೆ ಕರೆದು ಆಯ್ಕೆ ಸಮಿತಿಯ ಕ್ರೋಢೀಕೃತ ಅಂಕಗಳ ಹಾಗೂ ಸಂದರ್ಶನದ ಅಂಕಗಳ ಆಧಾರದ ಮೇಲೆ ಈ ಕೆಳಗಿನ ವಿವರದಂತೆ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಆಯ್ಕೆ ಮಾಡಲಾಗುತ್ತದೆ. ಸೆಕೆಂಡ್ ಮಿಲ್ಲರ್ ಮಂಜುನಾಥ್, ಫಸ್ಟ್ petitioner. Third one ಮಿಲ್ಲರ್ ಜಯಣ್ಣ, third petitioner.
Yes.
Kind but they have been appointed. ವಸತಿ ಹಾಗೂ ನಗರ ಬಡತನ ನಿರ್ಮೂಲನಾ ಮಂತ್ರಾಲಯವು ದಿನಾಂಕ 25/6/15 ರಂದು ಪ್ರಧಾನ ಮಂತ್ರಿ ಆವಾಸ್ ಯೋಜನೆ ಜಾರಿಗೊಳಿಸಿದ್ದು, ಈ ಯೋಜನೆಯನ್ನು ನಗರ ವಸತಿ ಯೋಜನೆಗಳಾದ ವಾಜಪೇಯಿ ವಸತಿ ಯೋಜನೆ, ಅಂಬೇಡ್ಕರ್ ನಿವಾಸ್ ಯೋಜನೆಗಳೊಂದಿಗೆ ಸಮನ್ವಯಗೊಳಿಸಿ ರಾಜ್ಯದಲ್ಲಿ ಅನುಷ್ಠಾನಗೊಳಿಸಲಾಗುತ್ತದೆ. Then kind is next para. Next page about second para from bottom.
Yes.
Page 23. ಈಗಾಗಲೇ my lord got it.
Yes.
ಕೆಳಗಡೆಯಿಂದ ಎರಡನೇ para.
Yes.
ಈಗಾಗಲೇ ಪ್ರಧಾನ ಮಂತ್ರಿ ಆವಾಸ್ ಯೋಜನೆಯಡಿ 21 ಜನ ವಿಷಯ ತಜ್ಞರು ಮತ್ತು 18 ಹೌಸಿಂಗ್ ಇಂಜಿನಿಯರ್ಗಳು ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು, ಪ್ರಸ್ತುತ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ತಜ್ಞರುಗಳ ಪಟ್ಟಿಯನ್ನು ಲಗತ್ತಿಸಿದೆ. ಸದರಿ ತಜ್ಞರುಗಳ ಸೇವೆಯನ್ನು ಮುಂದುವರಿಸಿ ಖಾಲಿ ಇರುವ ಸ್ಥಾನಗಳ ಮಾತ್ರ ಭರ್ತಿ ಮಾಡಬೇಕಾಗುತ್ತದೆ. That was issued on 28/11/2017. Pursuant to which, my lord, 3 persons were appointed. Page paragraph 8 I have said so in this fact.
Yes.
Of my petition. Just take paragraph 8 of my petition.
Yes.
Interestingly, at this stage, it is very pertinent to note that when the state level technical cell and district level technical cell were constituted pursuant to the meeting held on 16/10/2017 under the chairmanship of Chief Secretary, 3 more technical persons were appointed on the honorary basis, and they are Abhishek, Kempraju and Jain Kumar. There 3 persons were appointed. Now we have no issues.
Yes.
Then, my lord, we have been continued because we are already working there. Then kindly appreciate, my lord. Annexure D. D and D, my lord, passed by the Commissioner of the BBMP Tumkur. Sorry, Commissioner Tumkur Mahanagara Palike Tumkur. I'll just read, my lord.
Annexure D.
Their services are continued, kindly, my lord. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಂಜುನಾಥ PS, ಫಸ್ಟ್ ಪಿಟಿಷನರ್, ಯೋಜನಾ ಅಭ್ಯರ್ಥಿಗಳು ಮಹಾನಗರ ಪಾಲಿಕೆ ತುಮಕೂರು ಇವರು ಯೋಜನಾ ನಿರ್ದೇಶಕರು, ಜಿಲ್ಲಾಭಿವೃದ್ಧಿ ಕೋಶ ಬೆಂಗಳೂರು ಇವರ ಅಧೀನದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಲು ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಲಾಗುತ್ತದೆ. ಬಿಡುಗಡೆಗೊಳಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 2ರಂತೆ ಸದರಿಯವರ ಸೇವೆಯನ್ನು ಯೋಜನಾ ನಿರ್ದೇಶಕರು ಜಿಲ್ಲಾ ನಗರಾಭಿವೃದ್ಧಿ ಕೋಶ ತುಮಕೂರು ಇಲ್ಲಿಗೆ ಸ್ಥಳಾಂತರಿಸಿದ್ದು, ಉಲ್ಲೇಖ 3ರ ನಿತ್ಯ ಸದರಿಯವರು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿ ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಳ್ಳಲು ಕೋರಿರುತ್ತಾರೆ. ಅದರಂತೆ ಮಂಜುನಾಥ್ PS ರವರು ದಿನಾಂಕ 1/1/19 ಅಪರಾಹ್ನ ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಿ ಜಿಲ್ಲಾ ನಗರಾಭಿವೃದ್ಧಿ ಕೋಶ ತುಮಕೂರು ಜಿಲ್ಲೆ ಇಲ್ಲಿ ಕರ್ತವ್ಯಕ್ಕೆ ವರದಿ ಮಾಡಿಕೊಳ್ಳಲು ಆದೇಶಿಸಿದೆ. that is not respondent number 4.
Yes.
ಇವರು ನಿರ್ವಹಿಸಿದ ಕರ್ತವ್ಯದ ಪ್ರಭಾರವನ್ನು ಶ್ರೀ ಅಂಜನಮೂರ್ತಿ ಅಭಿಯಾನ ವ್ಯವಸ್ಥಾಪಕರು ಇವರಿಗೆ ಹಸ್ತಾಂತರಿಸಲು ಸೂಚಿಸಿದೆ. Accordingly, they have reported to the 4th respondent, project director. So also he also second petitioner. He has reported to the project director, 4th respondent. But they were kindly next page, annexure F. Annexure F, this is dated 12/3/2019. ತುಮಕೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯಲ್ಲಿ ರಾಜೀವ್ ಆವಾಸ್ ಯೋಜನೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಈ ಕೆಳಕಂಡ ಸಿಬ್ಬಂದಿಯನ್ನು ತುಮಕೂರು ಜಿಲ್ಲಾ ನಗರಾಭಿವೃದ್ಧಿ ಕೋಶ ಈ ಕಚೇರಿಗೆ ನಿಯೋಜಿಸಲಾಗಿದೆ. They were deputed to the project director because so ನಗರಾಭಿವೃದ್ಧಿ. Then they have reported there. Then kindly see when that is the case, on 30th October 2021, annexure C, annexure J, that is a challenge. Annexure J, J. When they are continuously working for more than 8 months, for no reason, they have been asked to go, without any notice, etc.
Yes.
Allowing the other 3 persons to continue there.
Yes.
They were subsequently appointed 3 persons. Now we have been appointed in 2013. That's how I did. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಂಜುನಾಥ್ PS ಯೋಜನಾ ಅಭಿಯಂತರರು ಹಾಗೂ ಜಯಣ್ಣ ಸಾಮಾಜಿಕ ಅಭಿವೃದ್ಧಿ ತರಬೇತಿ ಸಂಯೋಜಕರು ಇವರುಗಳನ್ನು ಉಲ್ಲೇಖ 1, 2, 3 ನಿರ್ದೇಶನದಂತೆ ಉಲ್ಲೇಖ 4, 5 ರಲ್ಲಿನ 1, 2, 3 ನಿರ್ದೇಶನದಂತೆ ಉಲ್ಲೇಖ 4, 5 ರಲ್ಲಿನ ಕೆಲವು ಷರತ್ತುಗಳು ಒಳಪಡಿಸಿ ರಾಜೀವ್ ಆವಾಸ್ ಯೋಜನೆಯ ಅನುಷ್ಠಾನಗಳನ್ನು ಕೋಢೀಕೃತ ಗೌರವಧನ ಕನ್ಸಲ್ಟೆಂಟ್ ಪೇ ಆಧಾರದ ಮೇಲೆ ನೇಮಕ ಮಾಡಲಾಗುತ್ತದೆ. ಅದರಂತೆ ಇವರುಗಳು ಸೇವೆಯನ್ನು ತುಮಕೂರು ಮಹಾನಗರ ಪಾಲಿಕೆಯಲ್ಲಿ ಪಡೆಯಲಾಗುತ್ತದೆ. ಯೋಜನಾ ನಿರ್ದೇಶಕರು ಜಿಲ್ಲಾ ನಗರಾಭಿವೃದ್ಧಿ ಕೋಶ ತುಮಕೂರು ರವರು ಪ್ರಧಾನಮಂತ್ರಿ ಆವಾಸ್ ಯೋಜನೆಯಡಿ ನಗರ ಮಟ್ಟದ ತಾಂತ್ರಿಕ ಕೋಶದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ವಿಷಯ ತಜ್ಞರುಗಳ ಟೆಂಡರ್ ಕರೆಯಲಾಗಿದೆ. Kindly see that annexure C issued by the government only for the existing vacancy only. I just
yes.
One second. ಈಗಾಗಲೇ ತೋರಿಸೋ ಇರುವ ಖಾಲಿ ಇರುವ ಸ್ಥಾನಕ್ಕೆ ಮಾತ್ರ ಅವರು ಟೆಂಡರ್ ಕರಿಬೇಕು. As per annexure C page 23. Just I'll read. Page 23. ಪೇಜ್ ನಂಬರ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ, ಬಾಟಮ್ ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ. ಈಗಾಗಲೇ ಪ್ರಧಾನಮಂತ್ರಿ ಆವಾಸ್ ಯೋಜನೆಯಡಿ 21 ಜನ ವಿಷಯ ತಜ್ಞರು ಮತ್ತು ಹೌಸಿಂಗ್ ಇಂಜಿನಿಯರ್ಗಳು ಕಾರ್ಯನಿರ್ವಹಿಸಿದ್ದು ಸದರಿ ತಜ್ಞ ಸೇವೆಯನ್ನು ಮುಂದುವರಿಸಿ ಖಾಲಿ ಇರುವ ಸ್ಥಾನಗಳಿಗೆ ಮಾತ್ರ. ಇಲ್ಲಿ ನೋಡಿ, ಇಲ್ಲಿ ಪ್ಯಾರಾ ಯೋಜನೆ ಪ್ಯಾರಾ annexure J ಯೋಜನಾ ನಿರ್ದೇಶಕರು ಜಿಲ್ಲಾ ನಗರಾಭಿವೃದ್ಧಿ ತುಮಕೂರವರು ಪ್ರಧಾನಮಂತ್ರಿ ಆವಾಸ್ ಯೋಜನೆಯಡಿ ನಗರ ಮಟ್ಟದ ತಾಂತ್ರಿಕ ಕೋಶದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ವಿಷಯ ತಜ್ಞರುಗಳ ಟೆಂಡರ್ ಕರೆಯಲಾಗಿದೆ ಎಂದು ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿರುವುದರಿಂದ ಮೇಲೆ ತಿಳಿಸಿರುವ ವಿಷಯ ತಜ್ಞರಾದ ಶ್ರೀ ಮಂಜುನಾಥ್ ಮತ್ತು ಜಯಣ್ಣ ಇವರು yes, earlier 2013.
No, that is not under tender. What is your appointment?
That's why kindly see,
Annexure A.
Annexure A, I have been appointed on the basis of the notification interview. We have been interviewed on the basis of merit. You have been selected.
Yes, who is appearing for Tumkur Managra?
The competent appointing authority is the deputy commissioner, my lords.
No, now your endorsement has been challenged. Your endorsement says petitioner has been appointed through contract. That is wrong. He has been appointed after calling for the notification.
Yes, as a specialized lord in subject, engineering subject.
My lords, and thereafter in 2018, we received a letter from the managing director of the Rajiv Gandhi Housing Corporation Limited stating that directing us to relieve the petitioners and directing them to report to District Urban Development Cell, my lords. And in compliance to that only, the petitioners were relieved on 1/1/2019, and they were directed to report to the District Urban Development Cell.
No, that and all I have seen. You come to that annexure J.
One more, my lord, one more aspect.
Annexure J. ತರಬೇತಿ ಇವರು ದಿನಾಂಕ 20 ಅಪರ್ಣ ಪಾಲಿಕೆಯಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಲಾಗಿದೆ. It is not that they have been sent to deputation to other department. They have been relieved from the service.
Yes, my lord. Kindly see the 3%.
My lord, I will place one particular letter on record wherein we've received that letter from the Rajiv Gandhi Housing Corporation directing these petitioners to be relieved, and they were directed to report to the District Urban Development Cell, my lords. I will
Scheme came in the year 2017 and scheme came in the year 2017 and it was concluded in the year 2024 December 31st, Lordship.
No,
The
now.
Pradhan Mantri